Clear, Mr. Lordship.
Clear.
My lord, this is the matter of 1962 land acquisition matter. Till today, we have not got compensation. Already 2 generations have passed away. So matter is urgent, it may kindly be listed on 16.5.
Is this a new matter?
No, it is a matter of 2015. It was in hearing list. It is off listed due to reasons not known to us.
Huh?
It was in hearing list. On the before the last list.
So it's not in this hearing.
This list it is not listed. The other day I mentioned it is said that it is not listed in this time.
You go to the registry, you tell them. Registry. We are unable to cope with the listing. Then you go to the registry. Well, you try that. Yes.
May it please, my lord. My lord, I beg to mention item 17 with the consent of the
Yes.
other side. My lord, in this matter, we need to obtain some instructions. I pray for 4 weeks' time, my lord.
Why?
My lord, we are working on some negotiations, my lord.
What negotiation?
My lord, regarding the payment of certain dues. And I do not have the updated.
No, you wait. You wait.
My lord, in item number 28,
Yes.
my lord, in item number 28, I am for the petitioner. With the
Yes.
consent of other side, lordship, matter may be passed over for the day, my lord.
Okay. Right. On the prayer of Mr.
R. Karim.
R. Karim, who submits that he has taken the consent of the other side. This is the matter. Who is the other side? Who is on the other side?
Government is there, lordship, and Rakesh Dubey, advocate, private
Where is he?
correspondent,
You call him.
lordship.
You
Otherwise,
call him.
consent, they have given lordship.
No,
He might
Mr.
be
Counsel,
other-
you see
other
what
person.
happens is I have had number of instances where we have adjourned the matter and then later on the other side comes and said we have never given consent.
Lordship, in this case, we have taken consent from. all
That
the
is what they
respondents, my lord.
say. Those cases also they said the same thing. That's the problem.
My lord.
You come, you see,
lord,
you see
let-
both
let-
sides are there, no problem. Only thing is that
Lordship, let me find it. Okay.
May it please, okay. I beg to mention one new WPC, my lord. And in this petition, I am assailing a notice issued by municipal board for demolition of my house, my lord, before 13th of May, my lord. My lord, kindly list the matter for hearing on 12th tomorrow, my lord. That is,
13th of May, are you sure?
yes, your lord.
Okay.
Oblige, your lord.
May it please, Lordship, I beg to mention item 15 and 16 of today's list. Your Lordship. I am the petitioners in both these petition, Your Lordship. I've taken consent of the other side. I pray that the matter may be adjourned for today, Your Lordship, and come after 2 weeks, Your Lordship.
Who is here for the petitioner?
I am for the petitioner.
Who is for the
I am
respondent?
Respondent number 3. He's a
So
private.
no
private-
objection. Okay, right. On the prayer made by the petitioner's counsel, which is not objected to by Mr. U. Chaudhary. Then counsel for the respondent number 3. List the matter after
2 weeks.
2 weeks.
Oblige, oblige.
It is your lordship. My lord, I'd like to mention item number 19 and 20, my lord.
Yes.
Miss MD Bora is unwell, so the matter may be passed over. I've taken consent, my lord. In item number 19, P. Mohanta,
Who is unwell?
my MD Bora, my lord.
MD Bora.
My lord.
Okay, have you, who is for the petitioner?
I've taken consent, my lord.
Item 20, I am for the petitioner, lord.
I'm for the petitioner in 19, my lord.
In 19 and for 20?
Lordship, I am for the petitioner, lord.
So any objection?
No, lord.
Okay, right. On the prayer for adjournment made on behalf of Miss MD Bora.
My lord.
SC Transport.
My lord.
SC Transport, which is not objected to by Mr. by the counsel for the petitioners. List the matter after
1 week, my lord.
Huh?
It may come up on any day.
after the week.
My lord.
Item 19 and 20.
My lord. Oblige.
So it's a separate actually, two separate orders for the petitioner, actually, petitioners. Yes,
May I please, Lordship?
yes.
Lordship, I beg to withdraw 2 of the arbitration petitions. Actually, Lordship, there have been some major
Okay.
defects in the pleadings.
Okay,
Much obligation.
My lord, item number 31,
yes.
with the consent from respondent, may I pray 2 weeks time to file affidavit as directed by this honorable court.
Your preliminary affidavit, you're for the FCI?
Yes, my lord.
I'm
Okay,
for the
right.
petitioner.
Huh?
I'm for the petitioner.
Yes, okay, right. Miss
B. Bora,
B. Bora,
appearing on behalf of BK Singh.
appearing on behalf of Mr. V.K.
Singh.
V.K. Singh,
Yes.
learned counsel for the FCI,
Yes.
is granted 2 weeks time to file preliminary objections, preliminary affidavit
Affidavit. Yes, ma'am.
as directed by this court in the last order. List the matter after 2 weeks.
Lordship, can you fix the date, Lordship? 1st of June,
List the matter on
1st of June.
1st of June.
First of June.
We have said 1st June.
May I please, Lordship?
Plus,
Lordship, in connection with item number 2, Lordship, I have filed additional affidavits. It may be called for. Lordship.
May I please, Lordship? I beg to mention a review petition for listing, Lordship. It was listed on yesterday, but it was left over. It is not reached.
When do you want?
Yes, Lordship.
When do you want?
Monday on 15th.
Very difficult. The week after that. We'll give a date the week after that. Next week we are full, madam.
Next week. Lordship will fix 25
25.
of this month.
Lordship, in item number 10 and 11, I have filed an additional affidavit on 8, Lordship. That is not on record, Lordship. It may be called for, Lordship.
Okay.
may I please, Lordship? I need to mention for listing of a case. It is a new case. And a motion is that wrongly listed in the orders on 8/5/2020.
New case. Where has it been listed?
8/5/23. It is a, I mentioned for motion state.
Where is it listed? But where was it listed? You said it's listed for order stage.
Order is wrongly listed. in
When?
order.
Today? In today's list?
Not today, 8/5/23.
8/5.
Give a date for.
It's a new case, she said. New case.
Yes.
No order has been passed. Has any order been passed?
Leftover.
Leftover. Okay, leftover. Leftover. It's a new case. Okay, then give next week. Next week, give a date. Monday.
So, Lordship, I beg to submit mention memo of listing of WPC. Mention memo for listing of WPC
Pending case.
pending case.
You go to the registry, madam. Go to the registry.
Matter may be fixed for tomorrow.
No. Go to the registry. Pending case, you go to the registry.
My lord, item number 28, Lordship. Lordship, government is here, Lordship.
20, yes.
Concentrated from our.
Yes. Here for the,
I for the petitioner, my lord.
okay, any objection?
In fact, from the government side, we have no problem, but there is a private respondent.
That is what,
Hard to pay.
that is what,
22.
yes, 28. Here for the private respondent.
28 for respondent for I am requiring.
Government, government.
So any objection?
No,
No, who is for the respondent number 5?
The respondent number 5 is yet to reach here with this court, Lordship. We have taken consent early morning.
Here for the,
I'm for 4, my lord.
We are waiting for respondent number 4, 5, and 6.
how can it be? There are only 5 respondents.
Item number
28, 29.
is 28.
28, there are only 5 respondents, madam. You cannot be appearing for 6. So what happened to 5? Give me item 28.
For private respondent, R. Dubey is appearing, Lordship. He is yet to reach in this court, Lordship. Okay.
We'll see. You wait.
Lordship.
You wait. Mr.
Wants to withdraw the matter.
S. Upadhyay,
Yes, ma'am.
learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition. Mr. Hasbot Thakur appears for
Respondent number 3.
respondent number 3. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn.
I'm highly available.
So that matter of blacklisting, my lord, where the petitioner was shown as lead partner.
Huh?
Petitioner was shown as lead partner in a joint venture, my lord, by the respondent number 11 by forging documents.
This item,
Item one, my lord.
item one.
Item one. Your losses, my lord, last time, past time, water, my lord. Granting them 1 week time, my lord, if railway board consider it, my lord. Because, my lord, no notice has been issued to us. My blacklisting, my lord, it is, tell my lord that notice must, is a must. Even hearing, my lord, in two Supreme Court judgments said hearing should be there. But so-called notice is a must.
Yes, what happened to the letter? My lord.
My lord, regarding the reply to be given by the concerned railway as requested by the railway board, as indicated by my lord in terms of the order. Lord, I have written to the railways, my lord, as on date, they have not provided me the said instruction.
Then we'll set it aside. What is it?
And my lord, so far as the impugn order is concerned, this particular impugn order was challenged earlier
Okay.
in another writ petition, wherein, my lord, the joint venture consisting of two entities was banned. Now the other entity has come before your lordship. Now they are praying that they were wrongly banned.
So no, there was a earlier writ petition.
No,
Yes,
earlier one,
I have-
just now, I have submitted that, my lord, copy. Because where she has admitted that he has for the documents.
Acha, in that other writ petition.
The other episode, because
the
there is
impugn
no
order
11,
is-
my lord,
Huh?
Impugn order is the same.
para 14.
Impugn order is the
Impugn
same.
order is the same.
And what did the court
And
do?
now, my lord, the railway is considering to revoke. Now that revocation of the. my
No,
lord,
wait a minute.
is under
What did, just a minute.
My lord.
Now, in the earlier writ petition, where the other side, they are the respondents here in this case.
No,
Yeah, the
no,
consortium.
in
No,
that case, I was not met.
no, in this case. In this.
Yes, I have met him at
You have made
respondent.
them, respondent.
11. That's
11.
11.
So this respondent number 11 in this case,
Yes,
in para
14, my lord.
Para
Para
14. Para 14 has admitted that
Fourth line, we interested to note that the use of false document as such has not been denied by the petitioner. Only expressed that they were not aware of the project. So they have admitted virtually, my lord. And railway board also says that, my lord.
14 says what? The learners have submitted.
Para 14 of the judgment, my lord. The learners clinic was submitted contract of petitioner is also very relevant in this case and is required to be taken into
Has not
consideration.
been denied by the petitioner.
Yes. And railway
Not
board,
been
railway
denied,
has
denied by the petitioner. And only that they are not aware of such problem.
and railway has issued a letter to us, my lord, page 58. We have noticed.
Page 58.
Yes. It is given to us, my lord.
Yes.
In reference to a letter number so and so, it was alleged by your firm that so and so, Dhubri Assam has participated in the tender on the basis of four documents so and so. Your firm, Tumkon so and so. And on that basis, my lord, they have issued that letter, page 59. To the railway board. Page 69, the letter, my lord, where you will also find, my lord, third para. On verification of the documents uploaded by Sumkon.
Where, page?
Page 69. For a reason your loss is granted time to table.
Yeah.
Third para, on the basis of the verification document uploaded by Sumkon so and so during the tender, information furnished by the certificate was found to be fake. And that is why, my lord, this chief engineer wrote to the railway board to revoke the, my lord, so far the petitioner is concerned. Page 70. Page 70, last two para is very important, my lord. In response to the clarification sought by this office, letter number sent by both Tumkon and Adjutant, the letter by the so admitted that the documents used in the tender are not connected with message Sumkon infrastructure, my lord. So I am, my lord, he admitted, my lord, that we are not that, my lord. And, my lord, how a party can be blacklisted without issuing a so-called notice also, my lord? I do not understand. I was shown to be late partner, my lord. It is Supreme Court judgment, your loss is latest judgment, my lord. Earlier judgments were there. I am just placing a latest judgment of the Supreme Court, my lord, incorporating all earlier judgments. And a similar case, my lord, I have already submitted earlier, my lord. In that case also, yes. That shock was, my lord, it must. And
No, no.
earlier case, my lord,
One thing at a time.
Yes.
One thing at a time.
Yes.
Who's giving me this?
My lord.
You.
my-
One thing at a time. So no, so this page 69 and 70 is a letter by the
by the chief
NF
engineer,
Railway,
chief engineer, by the,
chief engineer to the executive engineer.
Railway
Why
for revoking the, my lord, here. That letter. was-
to revoke the banning,
Yes,
to revoke the
my
blacklisting?
lord. Because I am an innocent person, my lord.
Then, so nothing has come out of this.
Nothing has come out. Last time, my lord, your losses granted 1 week time, my lord, to take a decision. Nothing has come out.
And with regard to the 13/4/23 letter issued by the railway board
My lord.
Yes.
to the chief administrative officer, no clarification has been made till now.
No, my
Yes.
lord.
So why should he suffer because of your delay?
My lord, but ultimately, my lord, the railway board has to take a decision. Well, I have.
But they're not, you see, the railway board has to take a decision. Now, because of the inaction of the NF railway,
My lord.
the ultimate sufferer is who? Why should he suffer?
Yes. That is the.
If they come to a finding that yes, we will give liberty to them to make an inquiry as to whether there was really a joint venture or not.
My lord, yes.
That liberty will always be there.
Yes.
Perhaps, my lord, their grievance is still under consideration. And
But
as-
you are not considering. That is the problem. When did you complete the consideration? Either 10 years or 15 years or what? When? That is his problem, no? You see,
That
why do
direction,
people come to
my
court?
lord will give dispose of direction, even direction within 10 days. They will decide, my lord. Because ultimately, as per the guidelines, my lord, which I have given, clause 16, my lord will see. The ministry's notification,
Yes?
that is the 9/11/22, my lord, clause 15.
Yes.
Clause 15, my lord, next page. My lord has got it.
Yes?
Any representation from the debarred firm shall be dealt with by the concerned directorate in the board. The revocation of the debarment order before the expiry of debarment period, if there is adequate justification for the same, shall be done with the approval of the concerned board members.
That is your
Lord,
thing. That does not bind the High Court.
My lord.
You don't want to do it. Look, this letter of yours is of what date?
My lord will give direction, dispose of the direction, my lord.
13/4.
My lord.
Now nearly 1 month has passed. Today is 11.
My lord, some administrative.
My lord, at least, my lord, your losses may, my lord, you stay may be granted just in the Houston case, my lord. I have submitted a copy. Houston case earlier, my
I
lord.
thought of disposing the entire thing.
My lord, they will dispose of with a direction, my lord. They will dispose of within 10 days.
No.
Directs, the railway board has to decide.
They
have
will
to
not do,
decide.
my lord.
They will not do.
Otherwise,
No. We have
because, my lord,
submitted
the order
request
imputed
of
is the
railway board.
same, one.
What we can do is,
Already.
we will stay the impugned order
Yes.
and you take a decision.
Yeah.
Till a
My-
decision is taken, the impugned order will be stayed.
My lord.
So that will serve both their
My
purposes.
lord.
That can
My
be.
lord.
And what is this judgment that you have given me?
My lord, that is it. My lord, the Supreme Court with series of this stage, my lord, that
Para,
notice is a must.
Huh?
So-called notice is a must.
Notice is a must.
Must.
Notice is a must.
That is the
This is 21 and
Yes. Because
yes.
earlier judgments have been quoted here.
Okay, that is judgment. Yes, okay. So no show cause notice was issued.
No. Nothing.
Then it goes actually. It
Yeah, on
goes.
that
On
basis-
that ground itself, it goes.
Yes.
But my lord, what
Yeah.
was banned was a joint venture. Now the another entity.
No, maybe a joint venture. But
Earlier-
to prove, but to say that we are blacklisting a certain entity due to having been a part of a joint venture, you have got to give that entity a chance to explain.
But the other entity is at wrong, my lord. If any, if
The
lordship
entities that,
interferes,
so if other entities are wrong, why you punishing the other one?
that we are taking a decision, my lord.
That you're taking, you're not, but at the end of the day, you're not only violating the Supreme Court's judgment, but you're not acting upon your own inquiry. within a reasonable time.
But may MB Premier, the best option would be to give a direction, my lord, to decide, my lord. The railway board has to decide. Because already, my lord, the representation.
No, that
which-
is okay. We can do that, but
No.
we'll stay the thing. Head Mr. J.N. Sayawala, learned senior counsel, assisted by, real senior counsel for the petitioner,
Yes.
assisted by Mr. M. Sayawala. Also heard Mr. H. Gupta, learned CGC. For all the respondents or what?
For 1 to 10, my lord.
10, my lord.
Huh?
1 to 10.
1 to 10.
For the respondents number 1 to 10. First up. The petitioner has challenged the impugned order dated
My lord, it is
29, 10.
29, 10, 21.
page
29, 32, page 30.
32.
32.
The impugned order dated 29/10/21
Yes.
issued by the respondent number
It is issued by my lord, railway board, my lord. Railway board.
Number 5, my lord.
It is respondent number 5.
by the respondent number 5.
Yes.
Mr. This C32, it says were served with a memorandum and statement of charges for banning of business dealings with them.
Huh.
Acha, it was given to the
Yes,
consortium,
yes, yeah, that other side.
not given to him.
No, no.
Uh,
And page 33 also, my lord, same thing, page 33 also, same. Same day.
33 also by the same authority or what?
Same authority, my lord. That is also railway board. That
And letter dated
29, 11, 20.
20, huh?
29, 11, 21.
29/11/21, huh? By so and so, by the same authority, yeah? Letters dated so and so and so and so by so and so. By which? But then one is for 3 years, one is for 5 years. What is this?
My lord, it is 5 years now. 3
So,
years,
huh?
that is for another, my lord.
That is for different. Sabari Krishna Enterprise.
We are one, my lord. We are
Serial
one.
number 1 is Samcon.
5 years.
Serial number.
Okay, 5 years.
5 years.
For a period of 5 years, has been blacklisted, huh?
Yes.
For a period of 5 years, with effect from 29/10/2021. Full stop. So you could not have been you could not have, the allegation against you was that you had participated in the tender process as a consortium,
My lord,
but as a joint venture,
joint venture,
which was not allowed.
not allowed. I'm not there. And let show me as lead partner.
Yes, the blacklisting of the petitioner company. That is Sumcon Infra, what is
Intra,
this?
intra,
Intra Ventures LLP
LLP.
had been done on the ground that the petitioner, along with MS Avi Jantrik Infratech Private Limited,
Yes,
had participated in the tender process as a joint venture,
yes,
while the requirements of the tender notice required the tenderers to be a single entity and not a joint venture. Correct?
well, single or joint, my lord, if it is qualified singly, because we are qualified singly, but the other party is not qualified singly.
Huh?
Other party does not qualify singly, you know, because qualification depends. Joint venture forms only for the purpose of qualification. So what we are concerned, we are singly qualified.
And they did not qualify
They did
singly.
not qualify.
So they have submitted forged documents.
Or the-
So what have I said?
The blacklisting of the petitioner company that is have been done on the ground that the petitioner allowing its private limited has participated in the tender process as a joint venture.
As a joint venture and had submitted forged documents. Full stop. The petitioner's counsel submits that the petitioner was never a constituent of the joint venture with the respondent number 11. That is MS Avi Jantrik Infratech Private Limited. The petitioner's counsel also relies upon para 14 of the judgment and order dated 11/4/2023 passed in WPC 7057/2021. In support of his submission that the petitioner did not enter into any joint venture with the respondent number 11. He submits that the said paragraph would clearly show, the said paragraph 14 in WPC 7057/2021 would clearly show that the respondent number 11 had admitted to participating in the tender process by forging documents. He has also relied upon the letter dated 17/3/2023 issued by the respondent number, chief engineer. Respondent number 3. To the respondent number. Well, it's 7. To reconsider / revoke the order of blacklisting / banning of business dealings with the petitioner in view of the respondent number 11 having admitted via letters issued by them that the documents used in the tender pursuant to tender notice dated page.
That's right.
6/9/22.
6/9/2022. Which page?
6/9/21.
21.
22. No, one. My lord, it is a
37/2018, my lord. 37/2018.
18.
Huh? What is the date?
37/18. Yes, 69, my lord. Page 69, second paragraph.
Second paragraph. It is that. 18.
Tender
Open down.
number, tender notice dated 37/2018.
Yes.
Were not connected with the petitioner and that the respondent number 11 had not conducted any business with them. Further, the petitioner had lodged a police complaint against the forged documents. Next paragraph. Besides the above points, the learned senior counsel for the petitioner has relied upon the judgment of the apex court in the case of UMC Technologies Private Limited versus Food Corporation of India and another, reported in 2021 2 SCC 551. Wherein
Paragraph 19/21.
it has been held that
19, my lord. Paragraph 19.
prior show cause notice granting a reasonable opportunity of hearing is an essential element of all administrative decision making and particularly so in decisions pertaining to blacklisting, which entail grave consequences for the entity being blacklisted. Full stop. The learned senior counsel submits that as no prior show cause notice was issued to the petitioner prior to the impugned letters being issued by them, issued by the respondents, the impugned letters should be set aside. Full stop. Next para. Mr. H. Gupta, learned CGC, submits that the question as to whether the blacklisting of the petitioner should be revoked is under consideration with the Railway Board. And in this regard, the Railway Board has issued a letter dated 13/4/2023 to the Chief Administrative Officer (CONS) Northeast Frontier Railway, asking him to clarify under what circumstances, the zonal railway, the NF railway, the NF railway had come to a had taken a decision to reconsider revoking the blacklisting / banning of business against the petitioner. He submits that the above letter dated 13/4/2023 issued by the Railway Board had been made in pursuance to the letter dated 17/3/2023 issued by the respondent number 3. The learned CGC submits that as no reply has been forthcoming from the NF Railway to the Railway Board in pursuant to the letter dated 13/4/2023, the Railway Board is unable to take a decision with regard to whether the blacklisting of the petitioner company should be revoked. He accordingly submits that some more further time should be given to the Railway Board to take a decision on the same. The CGC has also submitted the, what is this? What is this? This is, what is the guideline or what is
This
this?
is the guidelines for regarding blacklisting.
Submits that, has also submitted the guidelines applied by the Railway Board. The guidelines dated 9/11/2022 to be applied by the Railway Board. For considering cases arising out of blacklisting. He submits that in terms of guideline number 15 and 16 of the guideline number 15 and 16, the revocation of the blacklisting would have to be done with the approval of the Railway Board. He accordingly submits that some more time should be given to the Railway Board to take a decision with regard to the grievance of the petitioner. I have heard the learned counsels for the party. A perusal of the documents on record would show that no prior show cause notice had been given to the petitioner. As such, on this ground alone, the show cause, the impugned orders dated
29/10/21 and
page
29/11.
58/69, no?
Page 32, page 32 and 33.
32 and 33. The impugned letters dated 29/10/2021 and both are 29/10.
29/11. Second one.
29/11/2021 issued by the respondent number 7.
Correct.
Phone number five, my lord.
6.
6 are liable to be set aside. Full stop. The above being said, comma, in the writ petition, comma, that is, which page is that writ petition?
My lord.
Writ petition, where is that? Okay, in the writ petition filed by the respondent number 11 in this court, that is WPC 7057/2021. Wherein the impugned letters had also been put to challenge, comma, it is seen that the respondent number 11 has in para number 14 admitted to forging documents of another company, comma, which in this case is the petitioner,
Right.
comma, to enable the respondent number 11 to participate in the tender process. But I would say it's in spite of that, by adhering to the principles of natural justice, an opportunity was given to the petitioner to show cause.
Yes. It appears, my lord, he was also not proper forward, my lord.
Full stop.
But here, my lord, the direction was only to reduce the period. If so far, S111 is concerned. That para 36.
Full stop. The above clearly shows. No, the above admission made by the respondent number 11 in its writ petition, in the judgment and order dated 11/4/23 passed in WPC 7057/2021, thus indicates that the respondent number 11 had unilaterally forged documents and participated in the tender process without the consent and permission of the petitioner. Full stop. I said indicates, no? Indicate. Just appears to indicate. Full stop. Before that, before this paragraph, just I don't say. Full stop. Before we say that unsustainable, no, you just say one thing. Though the state respondents had apparently issued notices to the joint venture, alleged to the joint venture comprising of the petitioner.
Maybe name, my lord, that is Messrs. Samcon dash.
Petitioner and
J.
respondent number 11, comma, that is MS Sumcon dash Avijantik bracket JV.
That is at the address of the 11, my lord. Note the copy to.
In the address of
That's no 11.
the respondent number 11,
Yes.
comma. The said notices were never sent to the petitioner's address. Full stop, huh? Accordingly. Next, para. Then that page 50, page 70,
Page 69.
page 69.
Page 1.
A perusal of the letter dated 17/3/2023 issued by the respondent number 3 also states that in response to a clarification sought by the NF Railway, the respondent number 11 had admitted that the documents used in the tender were not connected with the petitioner and they had not conducted any business with the petitioner. What is this? Further, MS Avijayatri has lodged police complaint? What is this?
We have lodged police.
The respondent number 11 has lodged.
No, petitioner lodged, my lord.
No.
Oh.
MS Avijayatri Infratech has lodged
my
police complaint.
Maybe, my lord. They might have lodged, my lord.
Okay, anyway. Pustap. The said letter also states that as per the admission made by the respondent number 11 and the law officer's opinion, it was evident that the respondent, that the petitioner was not a joint venture partner and had not participated in the tender process, as a joint venture. You have taken part as a no.
Yes,
No.
no. I have not.
And had not participated in the tender process. Pustap. Next paragraph. The above also seems to indicate. The above also indicates that the petitioner not being a joint venture partner with the respondent number 11. The grounds for issuing the impugned letters by which the petitioner has been blacklisted does not appear to hold any basis. Does not appear to have any basis. Full stop. Next paragraph. Guideline number 14 and 15. No, 15 and 16. 15 and 16. Issued by the Railway Board on 9/11/2022. With regard to debarment/blacklisting, states as follows. You take it 15, 16. Full stop. A perusal of the same shows that any representation from the blacklisted/debarred firm shall be dealt with by the concerned directorate in the board before the expiry of the debarment period. The revocation of the blacklisting, if there is adequate justification for the same, shall be done with the approval of the concerned board member. And that court cases arising out of the debarment orders issued shall be processed/dealt with by the concerned procuring unit. Pusta. Though the learned CGC had made a prayer that the question of revocation of blacklisting/debarment of the petitioner from participating in any future tender should be left in the hands of the Railway Board, comma. And prayed that this court should not make any order in this regard, comma. This court is of the view that the is of the view that in terms of the judgment of the apex court in UMC Technologies Private Limited Supra and the admission that the petitioner was not a part of the JV joint venture. In terms of, no, and the admission by the, and the admission, not the, and the admission by the respondent number 11 in the judgment and order dated. And in the judgment and order dated 11/4/2023, passed in WPC 7057/2021, to the effect that the respondent number 11 had used forged documents for taking part in the tender process, comma. This court is of the view that some order with regard to the impugned letters would have to be made by this court. Accordingly, this court, accordingly, this court directs the respondent number 4. The
Six.
respondent number
5, 6.
2, 2, 5, and 6 to take a decision with regard to the petitioner's prayer for revocation of the blacklisting / debarment from participating in any future tender as reflected in the impugned letters dated 29/10/21. Is it 29 and
And 29/11/21.
29/11/21 issued by the respondent number 6 within a period of
30 days.
30 days from today. From today, full stop. Till a decision, in the meantime, comma, the impugned letters dated 29/10/2021 and 29/11/2021 issued by the respondent number 6, debarring the petitioner. Oh, instead we'll set aside and then let him take. Otherwise, it's going the opposite way.
My lord, insofar as the petitioner is concerned, because if lordship set aside, set only so far.
Okay.
Be contradictory to the order. already
Yes.
passed.
Then you cut that part, you just say, in view of the reasons stated above, the letters dated 29/10/2021 and 29/11/2021 issued by the respondent number 6, insofar as the petitioner herein is debarred, is blacklisted / debarred from
Participation in the.
Huh?
Participation in the.
from participating in any future tender is hereby set aside. First stop. The above is, however, subject to any decision to be taken by any final decision to be taken by the railway board. In pursuance to the letter dated 17/3/2023 issued by the respondent number 3 and the letter dated 13/4/2023 issued by the railway board.
Right.
The writ petitions accordingly disposed of. So we won't give them time limit. Let them take whatever time they want.
Yes.
What is this judgment you have given me?
You see, my lord, that is earlier, my lord, case,
You see-
similar case.
Huh? Oh.
Similar case, my lord, there also forgery was done.
Okay.
This court interfered, my lord.
Yes. You've got
That's
additional,
right.
you have filed additional.
Additional, we have filed, but in the meantime, Lordship, and earlier on the 8/5/2023.
My lord, I have
Lordship was pleased
instruction.
to ask that.
Huh?
Ask the opposite party to collect some information from the field instructions. PHE,
My lord had directed me on the
What
last
side?
occasion, so my lord, I have.
what instruction they have obtained. That after actually, if Lordship received that, then my affidavit, I will be permitted to read the affidavit, what that.
Well, his land was not found suitable because it needs erection of a large, huge capacity tanky, my lord. After digging 1 meter, my lord, water came out inundated, my lord. So it had to be shifted. It is a low lying land, and also the Gaon Sabha, my lord, I have pointed out on the next page, my lord, see that Gaon Sabha was not proper. Secretary was not there, my lord.
Huh?
That's good
Just a
point.
minute.
Secretary was not there, my lord.
With reference to, I have done submitted the report.
On the next page, my lord. Points have been highlighted.
Okay, next page, yes.
Yes, my lord. 0.5, 0.7, 8, 10, and 12.
Yes, I am. Mohammed Himmat Ali.
Yes.
The fact of donating the land to our department is not true. During conservation, we found that the plot of land offered by the said president is not within the coverage area of so. Now the area of so revised to towards the low end of census.
And also, my lord, if my lord
It
turns,
has already been installed.
yes, my lord, if my lord turns, my lord, there's a picture, my lord. No, don't digital. This is the condition of his land, my lord.
And this is land. Okay.
Everything will go to underground, my lord, if it's installed there, my lord.
Let us see your additional affidavit. Yes,
Lordship.
so what is your case now?
Lordship, actually, I could not follow what my friends submit.
Basically,
in
what
the
he's saying
meantime-
is that he does not want your land.
I am just trying to impress upon your Lordship. Lordship may kindly be, this to be produced actually, my writ petition 28 page.
Continue.
Writ petition filed there on that page 28, annex RF. That is the executive engineer's expert letter. What was the subject of the letter regarding disputed land and land finalization of newly sanctioned so and so under.
Yes, regarding dispute in land finalization. So he wants to finalize the land.
That fine. What prompted you to have another land already start working there
In the
without finding?
council, he doesn't want your land. It's like this.
No.
You have donated land.
Lordship,
Correct. They said that you have not donated land.
Lordship, I may be 29, page 29.
Yes.
Kindly 10, serial number 10.
Yes.
There, what is written there?
Yes.
Master para so and so, land disputes due to multiple landowners
Landowner involving
involving
different political
different
parties.
political parties.
Correct.
Yeah, what sort of why are you, then you have to decide.
It's
Which-
like this,
which
it's
land-
like this, it's like
No,
this.
no,
Mr.
Lordship.
It's like this. You are giving me a sweet, he's giving me a sweet. And now you are saying, no, you must have my sweet, you must have it. I am giving it to you. I don't want to eat it. I'll have
No.
diabetes.
Lordship,
Why should I have your sweet?
there should be impartial selection of land.
No, they
Why
don't
you
want
are-
your
why-
land.
why-
They're
why-
not taking it away.
While you are confronting with political divergence,
No,
divergent views,
sorry, no, case. They don't want your land, Mr. Council.
no,
You
Lordship.
take it back, put it in your pocket or whatever, or I don't know what you're going to do with it.
Yeah, Lordship, I
No
wanted
case.
wanted
Sorry.
to be collected actually, the panchayat.
Heard
Large
this.
number of panchayat persons have given their signature here.
Let it be. You go to the civil
These are the
court.
panchayat, this is democratic institution.
So what? It's like this. You want to do, you have donated your land?
Yeah.
They say that they don't want it.
He accepted it, they started working there, but what prompted you to go out without?
They dug it to see if it is suitable for constructing the whatever they were going to construct for that water supply. They think that it's not feasible.
They were at the outset, they accepted, they were pleased, they accepted.
Have you given a
done by
copy of
the-
this to him?
No, man.
This is that.
Just give it to him.
What prompted you to go to another land, which which
Just have
land was not
photocopy
tested?
done, give it to him.
Lordship, land was not,
Mr. Council, I can understand
they
if you
are-
have not been given money
they
for
are-
your land.
Lordship, while they are attempting to have another
It's
land.
like this, Mr. Council, you want to give your shirt to him. He said, no, I cannot wear your shirt, I'm too big. You say, no, you must have it, I'm giving it to you. He
No, no.
doesn't want it, it doesn't fit him.
Land to
What
be-
would he do with it?
No, land to be selected. Without selection of the land, how they can go to another
Okay,
land?
right, heard Mr. S. Huda, learned counsel for the petitioner. And Mr. D. Gogoi, learned counsel for the PhD. Full stop. The petitioner's case is that the petitioner had donated his land for installation of the master para PWSS bracket pipe water supply scheme under the Jal Jeevan Mission bracket JJM. Full stop. He submits that instead of making the construction of a water tank on the petitioner's land, the state respondents have started construction of the same on the land of the respondent number 10. Full stop. Mr. D. Gogoi, learned counsel for the petitioner, for the PHE, has where is that? It's gone for photocopy. Oh,
Well, sorry,
Huh?
my
no, I need the copy. What is written there? I have to see.
Apollo. I'm sorry, my printer gave up my.
Oh, it's for photocopying. It's for photocopying. Just make 2 copies. 2 copies.
It's a communication dated matter 10/5/23.
Submits that he has received instructions. No date.
Well, on the last page, man, 10/5/23.
He submits that he has received instructions. Via letter dated 10/5/23 issued by the Assistant Executive Engineer bracket PHE Jakhala Banda Subdivision. Kaliaba. On perusing the instructions received by the petitioner in persons to the letter, in persons to the above letter dated 10/5/2023. It is seen that the land offered by the petitioner, he was the president.
No.
Then?
He was not the
The president had offered.
President.
The land offered by the petitioner was not within the coverage area of the original master para PWSS. Full stop. As the area of PUB para PWSS was merged with Master Para PWSS, the petitioner's land fell towards the lower end of this PWSS with pipeline length of about 10 kilometers. Stop. Though the president of the Uttar Khatawal GP was requested to provide a separate suitable land for the said PWSS, but he wanted the scheme to be executed in the land of the petitioner. Full stop. On 18/3/23, the who is SO? What is SO?
Excellent. Hello.
So, Manoj, that, I don't know.
Okay,
The contractor was.
on 18/3/23, the contractor Sri Ripan Mondal dug a pit of 1 meter depth at the proposed land of the petitioner. And it was found that the whole pit was inundated by underground water, and all sides of the pit broke and fell inside. First up. It all the instructions received by him has been reflected in the letter dated 9/5/2023 issued by the SO bracket PHE side area section. You see that in the beginning, which also states that to execute the scheme, the PHE has to construct an elevated service reservoir of 70,000 liter capacity and underground service reservoir of 30,000 liter capacity, both having the foundation depth of 2.5 meters below the existing ground level. This, however, cannot be done in the petitioner's plot of land. The aforesaid condition of the land was informed to the executive engineer PHE Kaliabor, as well as the president of Uttar Khatawal GP, wherein the president replied that he would arrange a separate site for the PWSS.
Right.
He submits that though a GP, though a Gaon Panchayat, a Gaon Sabha was organized and people were asked to raise their hand in support of the land of the petitioner. Such a procedure could not be followed for a government scheme which is to be made for the benefit of the general public. The letter dated 9/5/2023 also states that the respondent number 10 also states that the respondent number 10 offered a plot of land for the scheme which was on high ground and in the middle of the coverage area for the said scheme. As such, the contractor was asked to execute the scheme at the land of the respondent number 10, observing all departmental procedure. The contractor has accordingly successfully installed the 150 diameter deep tube well of 280-meter depth on 30/4/2023 for the Master Para PWSS. The SOPHE has also stated that no soil test was done in the land of the petitioner as it was not selected for the scheme. Next one. The learned counsel for the PHE thus submits that the land which the petitioner alleges has been donated for the scheme cannot be, submits that the PHE cannot be forced to accept land allegedly donated by the petition. It is up to the respondent authorities as to whether they want to accept a donation with respect to land or any other material object. On considering the submission made by the counsels for the parties, this court is in complete agreement with Mr. D. Ugoy, learned counsel for the PHE, that no person can be forced to accept a gift if he does not want to accept the gift. In that way of the matter, the writ petition being devoid of any merit is dismissed.
All right.
The letter dated 10/5/2023 issued by the Assistant Executive Engineer (PHE) Jakhala Banda Subdivision Kaliabor, and the letter dated 9/5/2023 issued by the SO (PHE) Side Area Section is made a part of the record and marked as an X and Y respectively. In the beginning, you write third censor for the petitioner. Miss
N. Bora,
N. Bora appears for
respondent number 3 and 8.
3 and
8.
8. Mr.
S. Burwa for 1 and 4.
S. Barwa for
1 and 4.
1 and 4. And Mr. D. Ugoy appears for the PHE.
All right.
Mr. Gogoi, you don't need this then. Okay, we'll make it. Then images. Annexure X. Annexure Y.
Wait, please, Lordship. Well, item number
Lord,
3 and
before
7
my
is the.
Senior staff, my lord.
My lord,
My lord, I was not served with the copy.
my lord,
I was not served with the copy, my lord, and my name doesn't reflect the cost list value in the.
Anyway, so this matters have been
my lord, this, the Lordship will issue notice because this matters.
already
Lordship had
bunch.
refused the
Yes.
interim order.
My
Let the notices go. And in fact, in a connected matter,
They
the
are
government
being
has
heard.
already filed their affidavit,
Ah.
to which we'll file a reply.
Okay,
And we wanted an expeditious hearing. We'll take the call on.
okay.
At this stage.
Yes,
the
yes.
Lordship
Heard
will-
Mr. D. Das, learned counsel for the petition.
Well,
DK Das,
DK
learned
Das.
counsel for the petitioners. Just make it one order. Learned counsel for the petitioners.
Thank you.
Issue notice returnable in 3 weeks. Mr. Ardhar accept notice on behalf of
My lord, handloom and textile, my lord.
Handloom and Textile.
My lord.
Handloom and Textile Department. Mr. D. Nath accept notice on behalf of.
DC, Deputy Commissioner Kamru.
What about the, okay, DC is number 5.
Five.
And enforcement squad,
Enforcement.
Acha, that is you, that is Ardhar.
That is one.
And for CDC, your CDC, what is your name? Huh? Mr. P.S. Bhattacharya, Charya.
Charya.
Charya. CGC accepts notice on behalf of respondent number 1. List the matter after 3 weeks. Extra copies of the writ petition be provided to the councils for the respondents. So this will be 3 to 7.
This tag along with 1961.
List this matter along with
1961.
1961 of 2023. So
Okay.
basically, they don't need to file affidavit.
No, because
That's already there.
that affidavit
Yeah,
is the
that's
stand of the
fine.
government.
So,
because
so
we
your,
have taken
your
the
reply
ground-
on.
Those are fixed on 16th. Coming.
Yes, it's fixed on, because we have taken the ground of proportionality.
Okay, what is the case number you said? 1
It is 1961.
of 2020.
Yes, madam. Obliged.
30.
May I please your lord? My lord, I am appearing for caveat of lordship, respond number 5 to 12. Lordship. Caveat may be discharged.
Huh?
Yes,
Yes, that will be discharged. So what do you want right now? So the
Lordship,
respondent,
my
number.
only
So your
priority-
case is that the order
have
was
to-
passed without hearing you.
Yeah, that's.
So you want to be heard.
Hard. That much, your lord. Lordship, in our appeal, nothing, no allegation, nothing against them. In order itself, nothing against them, lordship. And more so, there is the statutory provision of review. Lordship.
Okay, that's correct.
Review 112, 111 subsection 2, lordship.
In this book.
This book, lordship. Section 111.
Page?
This book, lordship. This
Oh,
book.
this
page
book,
81.
Is it here?
There, lordship.
Section number, section?
111, lordship.
111.
Page 81, my lord.
Section 111, lordship. Subsection 2, lordship.
Appeal or review.
Lordship.
The review and your pass by him at any time in 60 days. Yes,
Lordship, may kindly see one aspect, your lordship. So far as this appeal is concerned.
but he's not a party.
Party, that's what your lordship. And your lordship will kindly
Lordship,
see the
Our
order
appeal,
passed.
lordship, can you see the prayer part of the appeal? Nothing against them, lordship. Please, please.
Why should it be against me, your lordship?
No, but who had actually in the first instance,
We filed the appeal, lordship.
no, you filed the appeal, but the
Against
cancellation of the
Mem-
membership
our membership.
made by whom?
Yeah, board of directors cancelled our membership by holding 3 meetings, lordship.
Correct, and they are the board of members.
No,
They-
your
No,
No,
Here
That is the dispute, my lord.
Huh?
they are not, they are
That,
nothing.
my lord,
let
They
me
were
submit
removed
your.
by the chairman and they were co-opted as members.
I said they are co-opted members.
Co-opted members.
Oh,
The
Subsequent,
moment they will bring back your lordship, moment they were brought back your lordship, we will be out, your lordship. Therefore, your lordship, our rights
No,
Your
lordship,
lordship
and
will-
one more thing, lordship, they
for
cannot be
hearing are there,
co-opted
your lordship.
if remaining term is less than 2.5 years, lordship. Term is only remaining for 1 month, lordship.
Whatever
There
it is, your
provision
lordship.
there. And election is due on lordship
In the month of
24/6, 24/6, lordship. We will be deprived, lordship. And more so, lordship, nothing against them. No, lordship, can you see the
yes,
prayer?
let us see the order of the respondent number 2.
Lordship.
That is that, your lordship. Impute order
111.
111, your lordship. Your lordship will kindly, the persons who are heard, your lordship,
No, I'm not on that. Let us see the reasons.
heard the petitioners of the above respondents, peruse the documents submitted by both the parties, is found at 8 numbers of directors of BOD, namely so and so, the respondent here in your lordship. 10, your lordship, were found absent in the BOD meeting dated 28/11/2022, 30/11/2022, 2/1/2023. Consecutively as stated by ARCS Nogam. However, it also reveals from the report of the inquiry officers appointed by so and so dated 1/3/2023 that the copies of the letters of the 8 numbers of directors showing the inability to attend the meeting on 28 were available in the office of the ARCS.
Then?
Now it is further revealed that report of ARCS Nogam that the inquiry officer that the BOD meeting held on 2/1/2023, 12/1/2023 cannot be considered as BOD meeting due to lack of quorum, as only director of the board signed and attended the meeting. There is no evidence on record that board had co-opted 3 shareholders as direct
to form quorum for the board of meeting. Your lordship, this finding is wrong, your lordship.
Okay, next one.
Then your lordship, it is clear from the aforementioned fact that two valid board meetings were conducted on 28/11/2023 and 30/11/2023, which were not attended by the above mentioned 8 directors of the board, and no valid third meeting has been conducted. Moreover, it has been observed that on 28/11/2023 and 30/11/2023, within a period of 3 days, 2 board meetings were held. Whereas it is mandated by the bylaws of the society that minimum 4 days prior notice should be given to the members of the.
What about this?
Lordship, there is no such provision, your lordship.
Let us
in the
see.
bylaws. Lordship, provision is there. This is the.
Let us see. Let us see this whether this for 4 days
4 days.
is
mandated-
required.
Mandated, lordship. And secondly, your
Oh no,
lordship.
let us see only this.
This lordship.
Let us see whether 4 days is required.
Mandatory laws. Rule 34 lordship of the Cooperative Society Rules lordship 1956. 53 lordship. This rule is applicable as per section 120 of New Act lordship. Rule 34 lordship.
Rule 34.
34 lordship, flag mark.
Yes,
The mandatory lordship.
rule 34.
Lordship.
4 days required.
Lordship, that's for the, your lordship, the authorities to the board to defend your lordship.
Huh?
So that is for the board to defend.
No, whatever it is, whether it is for the board to defend or not, whether we have to see whether the rule has been followed or not. That's all.
Lordship will kindly see what will happen
No,
to
no, you
my
see,
right, your lordship.
you see, your right
Yes, your lordship.
can only come into play if the impugned order is bad in law.
No, your
Now, this aspect of the matter
lordship.
with regard to the period between the two meetings, 4 days notice is required to be made. These meetings were held within 3 days.
No, your lordship will kindly note one another. I have given a aspect. judgment also.
Huh?
The judgment of this honorable court
Yes.
lordship. Finding is there, lordship. That is your lordship, ultimately your lordship. The BOD meeting, your lordship.
Just a
in which-
minute, yes, sir.
Lordship, paragraph 9 of the judgment I have given, lordship. Finding is there, lordship. May I read, lordship? Paragraph
Yes.
9. I read from rule 34 of the rules, at least 4 days notice with a statement of business to be discussed in the meeting has to be given, and in the instant case, no talk of 4 days notice. I found no agenda or notice of the meeting scheduled on so-and-so was circulated. In fact, the meeting was convened at the personal initiative of the chairman who had telephonically informed a section of members, and under such circumstances, it is obvious that the meeting that was held on so-and-so was in contravention of the provision of the rule 34 of the rules. In this case, order passed by the registrar was upheld by this honorable court. Now, your lordship will kindly. Paragraph 12 is the one aspect. 11 and 12, lordship. 11 and 12, lordship. My incorporation is approved by the assistant registrar, your lordship, as a co-op member.
Maybe
But your
maybe.
lordship,
when you see your right flows from they being kicked out from the board,
legally.
illegally kicked out.
Legally.
Then now if their rights are restored, your right goes automatically.
No, your lordship, that is why your lordship, I should be.
You go to the
heard.
division bench. No,
I-
what we can do is, okay, you want to be heard,
Lordship.
we will issue notice, that's all.
No, sir.
We'll incorporate all. We'll issue notice after 4 weeks. You can go to the division bench.
No, your lordship, that is not
I
the
don't-
question of going to the
see,
division. bench.
Mr.
Since Your
Counsel-
lordship will pass an order. It is not necessary that I will always go to division bench. That's not my.
No,
but
no,
your
anyway,
lordship,
I've heard you. I've
what
heard
has
you.
fallen from your lordship's mouth, your lordship, but my case is only this, your lordship. We were co-opted by a particular BOD meeting that was accepted by the registrar, assistant registrar of Cooperative Society. They filed an appeal, your lordship. In the appeal, we were not made parties, your lordship.
Where is your right?
No, your
Your-
lordship. the
You see,
moment
there
we
is
were
no direct right
co-opted-
you have. Your right only rose when their membership was cancelled.
No, your lordship, the moment we were co-opted.
The
it is
moment their
incumbent-
rights are restored, you go.
No, that is why, your lordship, before restoring their rights, since we
No,
have
no.
come into their place, your lordship,
Heard,
we should have been heard, your lordship.
heard Mr. S. Bott Harper, learned counsel for the petitioner, who submits that the petitioners who had been co-opted as members of the board of directors of MS Dhupa Guri Samabai Samiti Limited. Why, where is that, where is the co-opted, where is the order?
That is resolution page 51.
51. That is the meeting of the minutes of the meeting of the BOD.
No, this is the cancellation, where is?
No, your lordship, resolution number
Same
two.
meeting,
Same.
same meeting.
Why the uh,
Resolution.
meeting of the, resolution of the board of directors on 12/1/23 in place of the respondents, private respondent. By the impugned, no, in view of the impugned order dated 27/4/2023 issued by the registrar of cooperative societies, Assam. Bracket respondent number.
Two, lordship.
Point number 2. Comma should be set aside. The case of the petitioners is that the respondent number of 5 to 12 were elected members of the board of directors of MS Dhupa Guri Samabai Samiti Limited in person to an election held on
Lordship 24/6/2018.
24/6/2018. In the fourth meeting of the board of directors convened on 12/1/23, comma, a resolution was adopted for cancellation of the membership of the private respondents number
5 to 12.
5 to 12 on the ground that they had been absent in the 3 consecutive meetings held by the board of directors on 28/11/22, 30/11/22 and 12 and 2/1/23. The respondents number 5 to 12. No, the membership, the membership of the respondents number 5 to 12 had been cancelled in pursuance to which provision?
43(7), your lord.
14/3, Lord.
43(7).
What is that section?
Section
43.
Section
Subsection
43(7)
7.
of the
Assam
Assam
Cooperative
Cooperative Societies
Societies
Act.
Act.
Assam Cooperative Societies Act 2007. Which provided that if a director failed to attend 3 consecutive meetings of the board without the permission of the president or chairman, comma, he would cease to be a director, comma, from the date of the 4th meeting. Consequent to the cancellation of the membership of the respondents number 5 to 12 as members of the, to the board of, in the board of directors, comma, right, in the meeting, in the 4th meeting of the board of directors convened on 12/1/2023, comma, the 3 petitioners herein were co-opted as new members of the Board of Directors
As per
Ye-
provision of 41(9) of
as per section 41(9) of the Assam Cooperative Societies Act, 2007, here and after referred to as the 2007 Act. The resolutions passed in the fourth meeting of the Board of Directors convened on 12/1/23 were thereafter approved by the competent authority. Full stop. Next paragraph. Being aggrieved, comma, the respondents number 5 to 12 submitted an appeal before the respondent number 2, comma, which was thereafter referred to by the respondent number 2 to the respondent number 3 for taking a decision on the said appeal. The respondent number 3, comma, that is the Assistant Registrar of Cooperative Societies, thereafter passed an order dated 15/3/23. What did it do? It
against us.
which 15/3/23 rejecting the appeal.
Rejecting our contention.
Rejecting the appeal of the respondents number 5 to 12. Full stop. Thereafter, the respondents number 5 to 14 file an appeal under
Section 111, subsection 1, Lordship.
section 111 subsection 1 of the 2007 Act
Yes.
before the respondent number 2.
117(3), page 100,
How does it matter?
Lordship.
The respondent number 3 thereafter passed the impugned order dated 27/4/2023, holding that not holding that, pass an order allowing the appeal of the respondents number 5 to 12 and allowing them to continue as directors till completion of their term. Full stop. Then, so any order for them, no order.
No, we are continuing, Lordship.
So
Now,
now,
question of continuation will come right once meeting is held by BOD, Your Lordship. If they have applied for that, Your Lordship.
okay, the next meeting only
Yes.
you'll be brought in.
It will be brought in. We have signed one
full
more
stop.
aspect, Your Lordship, that one submission, Lordship. There are two other petitioners, Your Lordship, whose membership has been cancelled way back, Your Lordship, in November, Your Lordship. Now they have, Your Lordship, by filing the same appeal, Your Lordship, by being petitioners to the same appeal, they also trying to enter into the.
That is a different issue.
That is, Your Lordship.
That's a different issue.
Not entertained that.
Not
Not
understand.
entertained by registered, Lordship.
Next, right.
One submission, Lordship.
Yeah.
All 4 meetings without quorum, Lordship, definitely. How can it be
Right.
quorum, Your Lordship? They have not come, Your Lordship. That's why for quorum, Your Lordship, 3 members can be incorporated. All meetings.
How much is the quorum? Quorum is made out of how many?
Nine,
Nine.
Your Lordship. And
So-
then five only attended.
Five.
4 meetings, Lordship.
So, and
Question of quorum, Your Lordship.
no, anyway, that is a different
My
issue. I'm not going into that.
Lordship.
The only thing is that meeting has to be held with giving 4 days notice. If 4 days notice not given,
Meeting
it's
is-
not a valid meeting, so it cannot be acted upon. That's all.
Lordship.
Only on that issue.
Lordship.
No quorum business. Anyway, so next, the petitioners council submits that in view of the impugned order dated 27/4/2023 issued by the respondent number 2, the respondents number 5 to 12 would be taken back as members of the board of directors in the next meeting, which would automatically entail the cancellation of the petitioner's membership to the board of in the board of directors of the said society, of the said cooperative society. He submits that the impugned order dated 27/4/2023 has to be set aside, inasmuch as the petitioners have not been given an opportunity of being heard by the respondent number 2 prior to taking a decision with regard to whether the cancellation of membership of the private respondents as directors was made. Full stop. Next paragraph. He accordingly prays that the impugned order should be set aside and the matter remanded to the respondent number 2. Is it your case? Respondent number 2. Who shall thereafter take a decision after hearing the petitioners and the private respondent. Next paragraph. Mr. What is the name?
MK Hussain.
MK Hussain. Appearing for the
Respondent number 5 to 12.
appearing for the respondent number 5 to 12 on the basis of a caveat submits that no right of the petitioners has been violated inasmuch as they have been co-opted as members only on account of the cancellation of the membership of the private respondent. Once the rights of the private respondents have been restored, the membership of the petitioners as directors would automatically come to an end. He also submits that the reasons given by the respondent number 2 for setting aside the cancellation of the membership of the private respondents was in terms of the 2007 Act. It was in 2007 Act, and as such, the writ petition should be dismissed. Next paragraph, Mr.
RB Goswami for MD Bora.
RB
Goswami,
RB Goswami appearing for Miss
MD Bora.
MD Bora,
For
learned counsel for the respondent number 1 and 2.
1, 2, and 3.
1, 2, and 3. What do you have to submit?
My lord, my submission that this is a completely reasoned order, my lord.
Submits that the impugned order
And hearing
dated 27/4/2023 is the reasoned order,
my lord.
and there is no requirement of hearing the petitioners prior to issuance of the said impugned order.
And they've taken permission, they'd informed before the first meeting that they didn't attend. They'd already prior intimation was given that they will not be able to participate in the meeting, my lord.
Postard. He also submits that the private respondents had given prior information to the to the
Yes,
president,
And no, your
Huh?
assistant registrar of cooperative.
to the assistant registrar of cooperative societies, that they would not be able to attend the board of directors meeting held on 28/11/2022. And as such, there was no occasion for the board of directors to have cancelled the membership of the private respondents. In terms of section
47. 43.
40.
7.
5.
43.5,
7.
43.7,
7.
43.7
7 months.
of the 2007 Act. Full stop. That's all?
And hearing was there by agreed parties.
Not by us.
Solicitor took the hearing of agreed parties.
Now, how does that matter? His case is not, he's not bothered about you, he is bothered about his.
Chairman was present, secretary was present, yes, his all were present.
I have heard the learned counsels for the parties. Full stop. On a perusal of the impugned order dated 27/4/2023, it is seen that various reasons have been given by the respondent number 2 for holding that the cancellation of the membership of the private respondents number 5 to 12 could not have been made. First stop. Without going into all the points and reasons given by the respondent number 2 in the impugned order dated 27/4/2023, this court is only confining itself to the second last paragraph of the impugned order, wherein it states that meeting of the Board of Directors was held on 28/11/23 and 30/11/23. That is within a period of 3 days. 2 board meetings were held. First up, however, it is mandated by the bylaws of the society that minimum of 4 days prior notice was to be given to the members of the Board of Directors for a board of meeting. Full stop. Therefore, the disqualification invoked, the disqualification of the respondents as directors of the board no, that's all. Therefore, you cut from therefore you cut first of. Which is that 4 days notice?
Rule 34 of Cooperative Societies Rules 1953. Worship.
Rules.
What's happened?
Next, you're right. Rule 34 of the Assam Cooperative, Rule 34
Like
of the
Assam Cooperative Society.
Assam Cooperative Society Rules 1952.
Lordship, Act is 2006, your lordship, how can rule be 1952, your lordship?
New
Huh?
Act,
Act is your lordship, 2000.
yes.
Must be, this is a new
Yes,
amended
your
act.
lordship. But the rules, how can rules be framed in 1952?
Lordship, kindly see section 120 subsection 2 of the
Section 120.
120 subsection 2 of the 2007 Act. New Act, Lordship. Section 120 subsection
Section 120.
subsection 2,
The savings clause, my lord.
saving clause.
And what was the earlier act?
52 Act, 49 Act.
Huh?
49 Act.
1949 Act, correct.
Lordship, kindly see rule.
Rule 34 of the Assam Cooperative Society Rules 1952, which has been made in exercise of the powers conferred by Section 100 of the Assam Cooperative Societies Act 1949, provides that at least 4 days notice of all meetings of the managing body of the meeting with a statement of business to each member should be given, specifying the date, hour, and place of the meeting. First up. Now it says out here managing body and out here director. What is the difference?
Same.
Same.
Executive body or managing body or director, same.
Full stop. Rule 2 bracket F of the 1952 rules provides that director means a member of an administrative council, managing committee or any managing body of a society, as the case may be, vested with the powers of its management. Full stop. Rule 2 bracket E of the 1952 rules provides that society means a registered cooperative society, registered or deemed to have been registered under the Act, and includes a society formed after amalgamation of such two or more societies or by division of such an existing. No, that's all. Just say means a registered cooperative society, registered or deemed to have been registered under the Act. Full stop. Next para, you right? The Assam Cooperative Societies Act 2007 was promulgated and came into effect from 10/3/2012. And the same repealed the earlier Cooperative Societies Act 1949. Full stop. The said section 120 bracket 2 of the Assam Cooperative Societies Act 2007 provides that all appointment, rules and orders made, notification and notices issued, all transactions entered into, and all suits and other proceedings instituted under the said Act. That was 1949 Act. Under the Cooperative Societies Act 1949 shall continue and shall, so far as may be deemed to have been respectively made, issued, entered into, or instituted under the 2007 Act. Next. As can be seen from Rule 34 of the 1952 rule, 4 days notice was a mandatory requirement for holding meetings of the board of directors. However, the respondents number 5 and 12 were apparently absent in the board of director meetings held on 28/11/22 and 30/11/22 and 2/1/23. The difference between the date of holding the BOD meetings between 28/11/22 and 30/11/22 is only 3 days. In the case of so and so reported in 2009 4 GLT 622, this court had held that Rule 34 of the 2000 of the 1959 rules required at least 4 days notice. It also held that a meeting of the managing committee convened in contravention of Rule 34 there was enough justification for the Registrar of Cooperative Society to pass the impugned order, setting aside the action taken by the managing committee. First up. In view of the decision of this court in Supra, this court finds that there is no infirmity with the decision of the respondent number 2 in holding that in finding fault with having two board meetings, two board of directors meetings within 3 days. In that way of the matter, there is in that way the matter, for the first step further, as the rights of the petitioners arise only on the basis of the rights of the respondents number 5 and 12 having been taken away, the rights of the respondent number 5 to 12, respondent number 5 to 12 having been restored in terms of, in view of violation of the law, violation of the 1959 rules by the state respondents, by the state respondents, this court does not find any reason to set aside the impugned order just because the respondent number 5 and 12 were not heard by the respondent. Just because the petitioners were not heard by the respondent. The fact remains that the action of the fact remains that the cancellation of membership of the private respondents having been done in violation of the law and which has already been settled by this court in the writ petition is without any merit and accordingly the same is satisfied and called same is dismissed.
Obliging.
Oh. Actually, I think I've heard you all. I think I will reserve the judgment and pass it by next week. Yes, okay. This heard. There's nothing much to say, I think, anymore. I just wanted, I was thinking whether some clarification would be needed, that's all. I think I've heard you all, there's
Yes,
nothing much.
my
to say.
submission is over. I do not have anything to add. We have also placed the records.
The records I have not seen, where's the record?
Records we have placed.
Is that the records?
But there is no disputed facts also.
No, I just want to see the
Yes.
the records.
Yeah, we have it.
Yes,
Okay,
just
everything
give-
is flag marked. Yeah.
Just give me the record.
What sole case is that? 790 number of cases.
That is your case.
That is our case.
That is your
On a
case.
very limited scope. Campus. Original records already placed the other day, Lordship, and this is the photocopies.
Where is the original records? I have not seen it.
Same color cover, that's right. Blue color.
Oh, this is the one, okay. Okay, I'll see this.
Lordship. Highly obliged, Lord.
I think this is not required then.
That will be more convenient if Lordship will.
Okay, I'll see both.
Yes. In case of any doubt, Lordship may verify the original. Highly obliged, Lordship.
No, you keep it. Just say that, you see the last order, the names are there. So just put the names again, they say hearing concluded, judgment reserved.
Item 11, my lord, that affidavit has been sent for vetting, my lord. 2 weeks may be given. Item 11.
What is this matter about?
Yes, Lordship. Petitioner is the registered OBC Association of NFL zone. Now, Lordship,
Wait a minute,
item number 10,
11 and same parties.
same party. I'm
Item
placing
number
the facts,
10,
my lord.
Item number 10, my lord, their tenure is already over, my lord.
And what about 11?
11, my lord, they have, my madam is there, my lord, as a respondent.
I'm placing the facts, Lordship.
Just a minute.
My lord, here, my lord, he has challenged the circulation of the new meeting, my lord, new committee.
New
In,
So,
in,
my
in
lord-
which one, in which one?
My lord, in item number 11, my lord.
Okay, in
No,
10,
no,
what is the challenge?
Yes, my
What
lord.
is the challenge in item
In
10?
Item number 10, my lord, page 79, they have, my lord, they were formed, my lord, on 6/8/2019, my lord.
Just a minute, page
79 of the writ petition, my lord.
17,
79.
79, my lord.
79.
Yes, ma'am. My lord, this committee, my lord, that was considered for a period of 2 years, my lord, this para.
Yes,
2 years from the date of taking over sirs.
yes.
My lord, thereafter this was circulated, they have taken over sirs in the petition also they have mentioned. And now, my lord, there was illegality in the formation of the meeting. And while these were pointed out, my lord, then by order page 94, my lord. 2020, my lord, they were suspended. After about more than 1 year. And thereafter, my lord, they have challenged this page 94, my lord. That's they are.
Page 94 is the impugned order.
Yes, my lord. This, they say, my lord, that without completion of our term, even if there illegality, the railway should not interfere with. So this is their ground.
Their ground
Now,
is
my
that
lord-
they, in the railways cannot interfere at all.
My lord, they say, my lord. Now, our ground is that, my lord, that's illegally, since we are giving the facilities for sitting arrangement office and all. So election should be, is a democratic process. There should be observer. There was no election observer. This was the, my lord, report came to the railway. Now, my lord, the new committee has been formed. I have filed a affidavit, my lord. New committee. In my affidavit in opposition, my lord. Page 42, annexure F, my lord. New committee form on
Page 42 of your affidavit.
yeah, annexure F, my lord.
Annexure F.
Last page, my lord. My lord, on 24 January 2021.
Wait.
Yes.
Page 42?
My lord, in item number 10, my
Yeah,
lord,
just a minute,
WPC 827.
Page 42. Yes,
Yes, my lord. And then new committee form. So now if they are at all agreed by the new committee, my lord, they should approach before the civil court as per their, my lord, rule, my lord, that their registration as per their, my lord, bylaw, my lord. Now, while filing this application, writ petition, my lord, item number 10, they have not challenged this, my lord. The constitution of the new committee. And even they challenge, this challenge will not before the Honorable High Court, before the, my lord, civil court. So my contention
civil
is
court
that, my
under
lord,
what, civil court under what law?
yes, my lord, this is there, my lord, the memorandum is there. Page 15, 37 of the writ petition, my lord. Oh, my lord, 107, sorry, 107, that is there, my lord. Legal proceeding, 102, it's 2, no? Plus 30, 102, my lord. I'm sorry, and is this written in 7 and somewhere 2, my lord, like that? 102,
102.
clause 30,
Yes,
legal proceeding. According to provision laid down in section 5 Society Regulation 1860, the society may sue or may be sued in the name of President General Secretary of the association. Well, this is the dispute between two
where
companies.
does it say civil code?
If it is to be
42,
sued,
Lordship.
my lord, then my lord.
Why not? You can't do, if you can't you sue by way of a writ petition?
My lord, if it is the sue, my lord, then the right title concern, my lord, then it is to be proved by evidence. before
Anyway,
the civil
anyway,
court. Now, my lord, by order dated lordship 23 to 2021.
page,
My lord, the lordship order passed in WPC 8 to 2021, my lord, from the order set, my lord.
8,
Item number 10, my lord, order dated 23 to 2021.
23, 2.
Yes, my lord.
Yes,
Well, status quo order was granted that therefore, even though their term expired, my lord, more than 2 years, my lord, they are continuing, my lord.
with regard to possession only, not with regard to their office. They cannot they cannot continue in office.
My lord, therefore, my lord, there is some complication. We filed a IA application also, my lord, for modification of the order.
No, it's not required. Status quo in respect of possession in respect of the
Yes,
official.
madam.
That's all. It does
So,
not
my
say
lord,
about their, they cannot hold office beyond their term.
Yes,
That's for
correct, my
sure.
lord. That may be clarified, my lord.
I will clarify that.
Yes.
Let
Yes.
me place the.
So
facts
far,
Lordship,
item
from my
11,
perspective,
my lord, may take up separately.
Yes,
Item number 10 is, my lord, infrastructure. In view of the tenure.
we'll take 10 first.
Mile.
11 will take separate.
Let me place
Yes,
the
yes,
facts, Lordship.
Yes,
Lordship, Railway Board has granted certain facilities to the registered officer association.
to the association, zonal association.
This practice came in the year 1997.
So, Mr. Council, so what do you want? They want to now, they take back the facilities.
No, now Lordship, our last elected list of office bearers is dated 6/8.
Mr. Council, first of all, item 10
Item 10.
is for which of the elected members? It is of which election, which year?
Our last list is dated 6/8/2019.
6/8,
That is for a
2019.
tenure of 2 years.
6/8, 2019. That is, okay, 6/8, 2019.
They tried to interfere with their list by interfering with the internal matters, which legally is not
Okay,
permissible.
now they cannot do, supposing,
cannot
they
do.
cannot do.
Yes. So
Okay,
before-
accepted, they cannot do it.
yes,
Now, your term expired when?
Yes, before expiry of that list on 5/8/2019, Lordship, tenure expired on 5/8/2019. Now, before expiry of that list, Lordship, fresh election was held.
Hmm.
And fresh election, that list of elected office bearers, that was placed before the general manager for circulation.
Hmm.
The new list. And I don't know, Lordship, fortunately or unfortunately, the earlier person who was the general secretary, he was again elected as the general secretary. Now, Lordship, what has happened? That list is before the general manager for circulation. They are not circulating. Railway Board circulars are there, which mandates them to circulate the list whenever they receive a application for circulation from the OBC Association. I have that circulars, Lordship. Those circulars are also part of the record in this item number 10 and also part of the record in item number 11, Lordship. Now, Lordship, suppose if this item number 10 is disposed of today, Lordship, the office will be vacated. That will be the difficulty and OBC employees will suffer.
You tell me one thing. And now, this, in item 10.
10.
You all are the persons who were
Last-
elected on 6/8/19.
19.
Right. You all having a office.
Office now, yes. With
Now you don't want to be shifted from that office. Now subsequently,
new-
there is another another group, another board, another office bearers,
list
group of
of
office
elected-
bearers. Where is their office?
No,
We could not given them, my lord.
no,
for
no,
this, my
I'm
lord,
submitting,
tenure.
Lordship.
You cannot give them because
Yes,
of this.
because of this, my lord. And my lord, para 10.
No,
then is-
supposing, so if the old persons, they shift, except for the general secretary, all of you should move out.
Yes, so if-
Now, what about the new ones? Where will you put them? In the place where they are staying?
if new,
My lord, they could not be accommodated, my lord.
If-
My lord, because this new committee has formed in supersession of the earlier committee.
So
Yes.
where are you going to accommodate them? Are you going
In
to
our place,
accommodate
our
them in the office of the old
Yes,
committee?
Yes, yes, my lord.
Okay, then it's good.
Yes,
Lordship,
my lord. My lord,
if-
kindly see,
if this
kindly
list
see
is
one-
circulated,
his
they
parent,
they will take over charge. Lordship.
yes, why not?
They will
When you
take over charge and
circulate
we will
it,
take
simple
over.
as that.
We have circulated.
But my difficulty is
We
that
have
office should not
Huh?
remain vacant. Office should not remain vacant, Lordship.
Whatever it is.
Until it is
You see,
circulated.
Mr. Counsel. You are not some persons who are not aboard. How many writ petitioners are here in this item 10?
They are represented by the general secretary, Lord.
Huh?
They are represented by the general secretary.
They are
Yes, they are
represented.
already over.
So except for the general secretary, all those,
Other members also, some of them are, most of them are common, Lordship.
Huh?
Most of them are common.
Most of
Lordship, in
them
the
are
newly elected list.
My lord, what he is submitting,
Newly
this is
elected
not
is
for,
the-
as per his pleading.
let us
Kindly
see
there
the
are
list,
things-
let us see the office bearers, the names.
Yes.
Name 6/8/2019. Lordship will find that in page 79.
Page
79.
79.
79.
Yes,
Lordship may make a comparison with the new list, Lordship.
yes, I will, that's what.
New list is, Lordship, item number 11.
Give me item 11.
Item
The new list is there in my
No, no,
affidavit. I have just. shown
In your
my-
affidavit, okay.
42, my lord.
Page
42, my lord.
42. Just a minute.
No, he's. No, new list is part of the next repetition, Lordship, page 21.
Okay, let me see 21.
Page 19, Lordship.
Page 20.
Page 19, new list, new.
Okay, you just
second-
tell me whatever, what is the name?
Here, Lordship. Page 20, Lordship, may kindly come, Lordship. The second repetition.
Just a minute. That is your list. And you were saying page 41.
My lord? Yes.
You were saying page 41.
My page 42 of the affidavit, my lord.
42
Yes, my lord.
of your affidavit.
Yes.
Okay. Yes, tell me. Mr. Counsel, all the persons are same in yours.
Yes, Lord.
What is this, huh?
Page 20 of the next repetition, Lord.
I have got it in front of me. Tell me.
Lordship will see General Secretary VP Ramarao,
No, let's go to the president. President is the same.
President Jagadish Besborua, same, Lordship.
President same. Working president same.
Working President,
Same.
same. Vice
Then vice president same.
Same. General Secretary, same.
Then all of them are the same.
Joint Secretary also same, Lordship. Organizing Secretary, two new members have come, Lordship.
Where?
Organizing ORG Secretary, ORG,
What is the secretary?
Puran Singh. He was not there in the earlier list. Puran Singh. And then next one, RTM Choduri. He was also not there in the earlier list. Now, this is the list pending with the general
Just a
manager.
minute. Now let us see the list of the respondent. Whether your list and his list tallies, let us see. Now his list is at page 42.
Yes.
RTI, I have.
Just a minute, Mr. Counsel. I am asking the questions.
I'm sorry, Lord.
Let us see your list, page 42.
My lord.
President is Suresh Kumar.
Suresh Kumar, my lord.
And out here he is giving Jagdish Bedbara, the same person as 2019.
Yes.
It is not matching.
No.
Your list doesn't match his list.
Yes.
So there is some trick being played here.
I have got,
Mr. Counsel, I'm not asking you.
My-
Please sit down.
I'm sorry.
Kumar, this one.
So you see,
Yes.
your list at page 42
42.
and his list at page 20 of the item 11. You give them the second copy. You don't even have a copy. Madam, where's your, Miss Gayan, where's your copy? Give them item 20, second copy. Look at page 20.
My-
I think we will call this Jagdish Besbaro. Let him come to court.
You go to meet them.
Page 20, you see his list and your list. It doesn't match at all.
My lord, this is the representation they have made before the authority to continue with the earlier, my lord, committee. With some little.
But that is not what he's saying.
My lord, this is not circulated by railway, my lord. This is the representation, it is continued for page 19, my lord.
No, that is what, no. I'm going to record everything what is being stated here.
Yes.
And I'm going to call the president,
Yes,
Jagdish Bej Barwa, since
Right,
he
yes.
says that he's the president. And I will see if what he's saying is correct.
My lord.
If he's saying it's correct, then you will have to do some homework.
Yes,
If what he says is wrong, then I'm going to dismiss for telling lies to the
Right.
court and cause heavy costs.
yes, my lord. And my lord, one submission, my lord. Just one submission, but he is submitting is not as per his pleaded case. Para 10, last occasion also, my lord, para 10 of the.
No,
repetition.
we'll fix. I just want to know.
He
There's no-
himself said his tenure is for 2 years.
Ah,
And now even without going to his tenure over,
ah.
now
No,
how he can.
no,
claim, my lord?
he's giving this. He's saying that, you see,
Yes.
nearly everyone is the same.
Yes,
Now I'll have to see.
yes,
Okay, right,
yes.
May I clarify one thing, Lord?
right.
Lord,
Heard, Mr.
G.J. Sharma, Lord. G.J. Sharma.
J. Sharma, learned counsel for the petitioner. Heard Mr. B.K. Das, learned counsel for the railway
Yes.
in WPC number 827/2021. And Ms. A. Gayan for the railways in WPC 3601/2022. Full stop. The issue is with regard to. No, besides the issues raised in this writ petition, in the two writ petitions, this court had made specific queries with the counsels for the parties. Mr. G.J. Sharma had been specifically asked as to whether the office bearers mentioned in page 80 of WPC number 827 were still continuing after the term had expired, that is 6/8/2019 to 5/8/2019.
21.
Full stop. Mr. G.J. Sharma had initially stated that out of the old office bearers whose term was from 6/8/2019 to 5/8/2019,
21.
the General Secretary, Shri V.P. Rama Rao, was elected for the subsequent term from, which is the subsequent term, from which date?
That list is not circulated, Lord. It's pending.
Just a minute.
My lord, the 6/8/2019, my lord.
From 6/8/2019.
Yes.
Full stop. However, Mr. G.J. Sharma has submitted that the new list of zonal executive committee members pertaining to the president to the office secretary in the from from August 2020. No, this is again different. From August 2021 is reflected in page 20 of WPC number 3601/22. On a bare perusal of page 80 of WPC 827/2021 and page 20 of WPC 3601/2020, this court finds that nearly all of the office bearers are the same, except for except for the organizing secretary. Srikant Yadav, Srikant, Srikant Yadav, and Shri Vijoy Yadav, Vijoy Yadav, who have been replaced by Shri Puran Singh and Srimati R.P.M. Chowdhury in the subsequent list of office bearers as provided in page 20 of WPC 3601/2022. Full stop. Next paragraph. On the other hand, Mr. B.K. Das has taken this court to page 42 of the affidavit in opposition filed by the respondents number 1 to 4 in WPC 827/2021, which shows that
New office bearer have been elected, my lord.
Huh?
New office bearer have been, my lord, elected.
which shows that the office bearers in page 42 are different from the page 42 19
20.
not 20, the other one, another page. There is another page.
Page 20 only.
Share page dangala omle.
42, 42.
Please read the entire order.
Heard Mr. G.J. Sharma, for petitioner, also heard Mr. D.K. Das, railway in WPC 827/2021. Ms. A. Gayan, for the respondent in WPC 3601 of 2022. Besides the issues raised in the two petitions, this court had made specific queries that the counsels for the parties, Mr. G.J. Sharma, had been specifically asked as to whether the office bearers mentioned in page 80 of the petition.
That's what 80. So whatever I said last
On
sentence.
the other hand, Mr. B.K. Das has taken this court to page 42 of the affidavit in opposition filed by the respondent number 1 to 4 in WPC 827 of 2021, which shows that the office bearers.
It shows that the office bearers in page 42 are not similar to the office bearers in page 20 of WPC 3601/2021, 2022. Puस्तक. While the president of the office bearers of the NF zone while the president of the office bearers in page 80 and 20, page 80 in WPC 827/21 and 20 in 3601/22 is Shri Jagdish Besh Barwa. The president in the affidavit in opposition filed by the respondents number 1 to 4 is one Suresh Kumar. Accordingly, Shri Jagdish Besh Barwa, accordingly, the learned counsel for the petitioner is directed to ensure that Shri Jagdish Besh Barwa appears in this court on the next day at 10:30 a.m. Similarly, Mr. B.K. Das shall ensure that Shri Suresh Kumar, whose name is reflected in page 42 of the affidavit filed by the respondents number 1 to 4, also appears on the next day at 10:30 a.m. List the matter. When? On Monday? Monday?
Wednesday it will be better.
Huh?
Wednesday.
This is the matter on Wednesday.
Well, I will communicate to appear Suresh Kumar. my lord.
Yes,
Yes.
that should be asked them. And you will ensure that this other person comes.
Yes, sir. My lord, obliged.
Because your two lists are different.
Yes. This list, these factors otherwise.
And, full stop, just right. This has become necessary in view of the stand taken by the councils that the list as reflected, the names of the office bearers as reflected in their affidavit is correct, true and correct, since the affidavits have been made under oath.
Obliged.
This fact was otherwise clarified by the general manager also by a recent letter, Lordship.
No, let me bring them, no. And you bring one thing,
My lord.
they have made a letter to you to forward to circulate the list of office bearers. You bring them on the next day.
Lordship may kindly be pleased to produce this, Lordship.
Now,
They
why
have
do-
clarified, general manager has clarified that Suresh Kumar is not figured in the list of criminal associations circulated by the railway. And they have forwarded the.
So
actual
then we
list.
will take action upon them.
Yes, Lord. Yes.
You see, these are questions of fact,
Yes, Lord. Yes,
not even a question of law.
Yes. Lord. What?
Oh, otherwise, you go to a civil court, both of you.
Yes.
Why should I look into all these aspects as a rate court? Disputed question of fact, I'll tell you both to go to civil court then.
Yes, ma'am. This is clash between the
No,
two
railway
groups, my
board-
lord. They are, my lord, private nature, my lord, who should hold the office.
No, because you see, Mr. Counsel, you have categorically stated that out of the old office bearers, only the general secretary was the same. But when I look at page 20,
All of them are,
not at all. Everyone is the same.
everyone is the
Ex-
same.
But that is not what you said to me. It's not that
Most of them.
is unless I have heard you wrong, and you have said all the truth, but I heard you wrong.
They are-
So you see, you cannot change your stand.
they are leaded
So
by
we'll
the
see, Mr. Counsel.
Interim order may continue.
We'll see. Until Wednesday, nothing will happen.
Obliged.
But they may throw us out, Lordship. Till Wednesday, it may continue. It was continuing since the. first day.
Okay, interim order to continue till Wednesday.
Till Wednesday. Much okay.
Yeah, please, Lordship may pass over the matter for the time being.
What is this matter about, madam?
Lordship, we had purchased a plot of land. Our names had not been mutated. Our name was mutated and we have been paying the revenue, but the respondent number 5 have illegally mutated their names for the plot of land.
So then who is to decide that issue? Is this court to decide whether the mutation was done correctly or not?
Yes.
Who is for the respondent number 5? You are the- What is your case?
I am the occupier of the land. And
Are you the owner of the land?
I am the occupier of the land.
Occupier, they're saying that they're the owner of the land.
The case is this, my lord, for construction of a road, the Zirat compensation was, order was passed for giving Zirat compensation to respondent number 5. And they have raised objection that they being the owner of the land, they are entitled to the Zirat compensation.
What is wrong with that? If they're the owner.
Because they will get the compensation so far land is concerned. So far Zirat is concerned, it is who is occupying the land.
Is it?
Yes.
I don't know. Like that.
Yes.
Well, let me see the law. I don't know. Show me the law. Where the Zirat is to be paid to the occupier of the land and not to the owner. Where is the law?
There is a judgment passed by this our court.
Yes, let us see that. So, supposing I'm the owner of a land
Yes.
and I've got a tenant. I make him a tenant. Tenant is different.
Tenant is different
Okay.
because I am the occupier of the land. My name was mutated. And they claim that they purchased the land, entire land, but their name was not mutated.
So that's what I'm saying.
Yeah.
But you are not denying the fact that you are not the owner of the land.
No.
You're saying that you're an occupier of the land.
Occupier of the land, my
You're occupying whose land?
land of the original owner.
Who is the original owner?
Mr. K.K. Sharma.
KK Sharma. And how are you? And is it agreed by you that KK Sharma is the owner of the land?
Yes, we purchased the land from him.
Or you purchased the land from us? So, your right flows from KK Sharma, according to you. Huh? So, but then you are just the occupier. So if, say, supposing I am the owner of the land, someone is occupying my land
No, that is.
as a tenant. No, it's not like that. I want to know the law. That's what. That's why I'm asking for a law, not a judgment. Does the judgment talk about the law?
Yes, husband.
It has to be based on some law. It cannot make a law by itself.
You'll also kindly look to the head note.
Huh? Head note.
It is that paragraph number. one more paragraph. Paragraph number 29. The acquired land falls under the covered portion of the land, which is a part and parcel of three registered cell deeds and contains the number of annual patta. On the spot verification, it is found that they reported that the petitioner were in possession of the possession. The landed court below, in conclusion, the petitioner is entitled to the zero compensation accordingly has been made. This court does not find any material irregularity or gross infirmity in the said.
Let us see the facts of the case.
I'm sorry, my lord.
Just
My lord, this
a minute, just a minute. I don't know.
My lord, here, simple case is this, my lord. There is some dispute regarding apportionment of the compensation. My lord. In this matter, because so far land is concerned, my lord, we have purchased the land. And that, my lord, they got a some wrong mutation, my lord, with the cycle officer, that has been cancelled by ADC, and that has been upheld by the revenue board. my lord. That has become final, my lord.
No, you're the owner of the land.
I'm the owner of the land.
Your land was acquired.
My lord,
The land was acquired.
Yes.
Under which law?
under this, my lord, right to fair compensation.
Under 2013 Act. And now you have not been paid the compensation amount.
My lord.
Now,
Because that was stayed because the revenue board appeal is pending.
no, now what is the dispute with the respondent number 5?
Respondent of five, my lord, they say that they have made that some construction there. We say we are making the construction.
You are manning the construction.
We
You are doing the construction work.
we have made construction, but they are, my lord, they are residing there. my
They are
lord,
residing there.
illegally.
Huh.
145 case was there. They were restrained from entering into the land also. That case was up to High Court, they obtained stay, but that has been vacated later on. Now, suppose there is some dispute regarding apportionment of the land.
Apportionment of land. Are they
The
claiming?
apportionment of compensation. Sorry, I'm sorry. Apportionment of compensation, whether they are entitled to the compensation for the house, Jirat or not. my lord, that is one aspect of matter which is to be referred by the under the Act itself, section 75. Section 75 of the Act says that it should be referred to a competent authority. My lord. But here, my lord, what happened? The collector, my lord, referred the matter to the circle officer. I'm submitting that circle officer, my lord, he handed it off to the petitioner, my lord, the respondent. And with him, my lord, he has asked for, my lord, some comments. But as per 70, this act, my lord, if you have also see, my lord, section 75. Section 76. my lord.
If you agree to the apportionment only,
My lord, I don't agree, my lord.
you don't agree, then how can this
No.
75 be applicable?
Certainly, they are claiming, my lord, they are claiming that they have.
No, I think there is some other provision.
The other provisions are also there, my lord. But this is the provision, my lord, I think will apply. Reference, that is another aspect of it.
No, just a minute.
Reference is another, my lord, because if I am not satisfied the compensation, I can ask the collector to make a reference, my lord. Huh? That is 54, my lord. No, 53,
64.
64, 64 and reference to authority, 64. That is well, if I am not satisfied the compensation. But here, well, the dispute is, he
And
is
the several person is agree the person. $76,
76.
not 75,
No, 76, my lord.
76.
So it is to be referred to the authority, my lord. How the matter can be referred to a circular officer, my lord? He has asked for comment from the circular officer, so that the amount can be.
So you are the owner,
I am the owner of the land, my lord. That
he is
is
the occupier.
He is occupying, my lord, illegally in the house constructed by me. He is giving some.
Where is the impugn order,
Yes,
impugn
my lord.
letter?
That letter is, my lord, at page 152.
Huh?
152.
152.
My lord. But the first was subject cited.
Now, where is your letter? Your representation?
My lord, yes. That we have said, my lord, 153. Well, then cycle of self, but it will happen. 153 we have said.
$153.
Yes.
So you have written yourself to the circle officer.
Because it was sent to them, my lord. We have objected to this, that, my lord.
Huh?
We have objected to that, my lord. If your lordship see, just I. Because.
This is
that-
by whom?
My lord,
No, this page 153, how did it start? Where is the starting point? And who is this person? Who is this Shri Sup Karan Jain? Who is
he
he?
is the, my lord, the main person of this petitioner.
He is the petitioner.
Yes.
Who is the petitioner?
No, my lord, this is, the, my lord,
Artificial limb and
charitable organization, and he is the charitable organization.
but how did it start? How did it go to the circle officer?
No, that is the 152 letter. This is I am challenging that it cannot be sent to the cycle.
No, I know, you're challenging. I have no doubt about that.
Yes.
That is very clear. But then why are you challenging this? Because this letter, 12/1/22,
Page 146, my lord. That is
has
the
been made,
Page 146, repression before the deputy commissioner.
huh?
Page
Page-
146.
Page 140.
This is filed by them, my lord. Understand? And this is our side, my lord. Submitted after hearing it was decided in that the payment of direct transfer of official government can be stopped to either party until a mutation of program of national ensure.
So you have not got the Zirat, but you have been given the Zirat or not given?
And not given, madam.
Not given. So now he says that 76 will apply. Let it go to the authority to decide. Authority as per authority is the land acquisition and rehabilitation resettlement
Now, it is the district judge, my lord, actually.
under 51.
Under
Under
district judge.
51.
Your lordship, kindly turn to page 93.
Just a minute. The appropriate authority, appropriate government shall established by notification, one or more authorities to be known and the land acquisition authority. Yes, so how do you say the district judge?
No, what is there notification?
Huh?
There is a notification.
There's a
As per
notification,
Section 53, my lord. If the lord is-
there's a notification. Do you have it?
No, we don't.
Then,
I was informed, my lord, that just I have not taken the notice. Anyway, my lord, whatever.
I have not gone through such notification.
Huh?
I have not gone through such notification.
notification,
I have not gone through it.
that's notification under section 53. No, whatever it is,
Whatever, I copied the authority, my lord.
whatever it is, he's saying, since there's a dispute with regard to who should get the money, apportionment of the money or whatever. In terms of section 76, the collector has to refer the matter to the authority who has to be constituted under section 51,
Yes,
51(2), in fact.
my lord.
So, now, because of that, we can direct the collector to refer to the authority. If there is a authority already constituted, if it's not constituted, then what happens?
My lord.
If if authority is not constituted, then we'll have to direct a constitution of an authority.
Well, 13 Act, my lord, now.
Huh?
10
2013.
years has elapsed, my lord, they have, although I don't have that copy of the notification, but.
It is there.
It is there.
You have seen it.
Let them produce the copy of the. Your lordship
Can you see in the Google or something? If there, say under section 51(2),
My lord, 51(2), yes.
51(2), if the authority is there,
Yes.
then we'll direct the DC to send it to the
Right.
authority. That's all.
Malady, your lordship kindly please turn to page 93.
93.
It is a letter to respondent number 5 by the deputy commissioner.
Tilen Das is the respondent number 5.
Yes.
You see, maybe you have been asked, but you see, it's your own submission that you are the occupier of land. You are not the owner of land.
Yeah, I am not the owner of the land.
That's what. Now he says that he's the owner of land. Now the issue is whether the owner should be given or the occupier should be given. So there is a dispute. So as per the act, since the land has been acquired under the 2013 Act, all disputes with regard to apportionment will have to be made as per the 2013 Act,
Yes.
or now though you have given me a copy of this order of with regard to payment of zirat to the occupier of land, I do not know if this is really the true correct law. I don't know. That will, and that is a different issue.
Therefore, I may be allowed some time to go through the notification if it is available.
My lord,
No,
I sorry, my lord, it is there, my lord.
Huh?
It is there.
No,
I
let us
just-
see.
My lord.
Let us see.
I'm just. What is that?
Storms erupting. Yes, yes, yes.
That very careful. my lord. That very-
Just give it to the senior counsel for the respondent. Let him see.
I'm giving. my lord. I'm
Acha,
giving
if for-
a-
if for-
I'm-
Let him see. Only thing, Mr. Saiwala, how do we know that this has been acquired under the 2013 Act?
My lord, yes, my lord, that your lordship.
You keep it, you keep it.
No dispute so far, my lord, this is. I'm just.
Your lordship, the government also filed affidavit in opposition.
Yes.
Your lordship kindly time, read the paragraph 9 of the affidavit.
Of the government affidavit.
Yes.
Just a minute. Government is respondent number? Okay, yes, page, para 9.
Yes.
Yeah, yes.
Okay. Paragraph 11 of this deponent notice and so and so to the land as regarding the compensation of the proposed roads.
Yes, no, that's all right. That's all right. Now, he's saying that his basic thing is that occupier of a land is not entitled to compensation. That is what he's trying to say. Even if he's saying that first of all, you're an illegal occupier. So he's saying that, so let the authority who is empowered to decide the issue, as per the law, decide the issue. So this is a question of fact. Whether you're an occupier, illegal occupier, we don't know.
My lord.
That's all. No, no, show me that how is it admitted by you that this land has been acquired under the 2013 Act?
Yes.
Okay, then it's okay. It's both of you. Then we'll send it, let it go. Any problem with that, Mr. Council?
My lord, I will be given 2 days time to whether the authority was formed or not.
It is here, right in front of you. It is here.
Yes.
It is here. This Registrar General Raktim's order also is here.
It is part.
It's already here.
Chief Secretary has.
Right. Heard Mr. G. N. Sahawala, Learned Senior Counsel, for the petitioner, assisted by Miss A. Bhattacharya. Huh? K. Also heard Mr.
A.C. Sharma.
A.C. Sharma, Learned Senior Counsel for the respondent number 5, assisted by Mr. J. Bhardwaj. G. Bhardwaj. Heard Mr. M. Tetia for 2, 3, and 4. And Miss G. Hazarika for respondent number 1. The petitioner's case is that he is the owner of land measuring 1 biga, just the facts correct,
Yes,
1 biga, 1 katha,
Yes.
4 lechas,
Yes.
covered by DAG number 187 of KP Patta number 202, village Abhaipur, Moza Sila, Senduri, Gopa, and the North Guwahati Revenue Circle of subdivision Kamrup Sadar, district Kamrup. Hey, order dated 10/3/22, second para. Full stop. The petitioner's counsel submits that the land of the petitioner has been acquired under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013.
Yes.
Hereinafter referred to as the 2013 Act. Full stop. The petitioners council submits that the respondent number 5, who is the illegal occupier of the petitioner's land, is also claiming compensation.
Direct compensation.
Is also claiming, Zerat compensation along with the petitioner. Full stop. He submits that as there is a dispute with regard to the
Portion.
you are saying apportionment means distribution.
Distribution. Yes.
So he submits that as there is a dispute with regard to the apportionment of the compensation
Or any part thereof.
or any part thereof, the collector has to refer the dispute to the authority in terms of section 76 of the 2013. Yeah, meeting. Oh, this already. I forgot. I've got a meeting at 1:30. I forgot, 1:50.
Well,
Okay. We'll after 2.
after 2.
It's in the first half,
Ah.
but some problem in the next, second half, my lord. I have
Okay,
medical duty. My lord.
23.
My learned friend is here, 23,
I'm for the respondents, my lord.
So when,
on 18, my lord, on 18, my lord. On 18, my lord.
18th is next month, next week.
Next week, my lord.
Is it possible? I don't know. Okay, we'll list it. What is the matter about?
Some tender
Canada,
process.
my lord.
The stay in operation.
Okay, item 23 and 24. On the
Yes.
prayer, and the prayer of the party, this is the matter on 18.
Obviously.
On 18, my lord. Obliged, my lord.
Accordingly, the counsel for the petition accordingly prays that the collector may be directed to refer the issue of the dispute between the petitioner and the respondent number 5
Regarding direct compensation.
regarding Zerat compensation to the authority in terms of section 76 and section
76, my lord, and 76. And then 51 is, my lord.
76.
76.
I read with
Read.
section
51. 51.
51 of the 2013 Act. Stop. Next, Mr. Penso, the learned senior counsel for the respondent number 5 submits that. Any objection?
No objection.
Submits that.
Time limit will be fixed.
Submits that he has got no objection to the prayer made by the petitioner's counsel. So he however submits that in terms of the judgment of this court, do I mention this? No need. He submits that in terms of the judgment of this court in Arun so reported in 2021 4 GLT 974. The Zerat compensation should be paid to the occupier of the land. So he also submits that he's a occupier of the, he's also submits that the respondent number 5 is the bona fide occupier of the land in question, which has been acquired.
With RCC houses standing there.
With
RCC houses.
with RCC houses.
Well, I dispute that, my lord.
Full stop. Which has been disputed by the petitioner. Which fact has been disputed by the petitioner? Full stop. Next paragraph. Yes, what have you got to say? Government? Okay, right. And the counsel for the state respondents submit that the matter may be referred to the authority in terms of section 76 and 51 of the 2013 Act. Full stop. In view of the consent of the parties, comma. You have to file a fresh application or
No,
what?
no, no, it is the collector who will refer the matter.
No, but where is your application to them that you wanted a portion? You want the dispute to be settled. It has to originate from you.
My lord, because
Okay.
I am challenging 152 page. That is with was, my lord, and they may be, ADC may be directed to refer the matter to the.
Okay, full stop. In view of the consent of the parties, comma, the letter dated 12/1/2022 issued by the Additional Deputy Commissioner Tamrip Emingao directing the circle officer, comma, North Guwahati Revenue Circle to make a detailed report of the compensation payable, of the Zirat compensation payable to either the petitioner or the respondent number 5 is hereby set aside. Full stop. The respondent number, the collector bracket respondent number,
I'm just.
My lord, by this letter 152, kindly submit a detailed report of payment of compensation, which then the one it is nothing to say,
okay, is don't, not to set aside.
not to set aside.
Okay.
Well,
Well-
that is with, my lord, sir, because.
Should not be acted upon.
Yes.
This is should not be acted upon. Should
And-
not be acted upon.
And so number 3, my lord.
Should not be
Additional
acted
deputy
upon,
commissioner
it should not be acted upon by the office of the deputy commissioner. But they can make a report, they can make a report. At the end of the day, they will have to make a report anyway. It should not be acted upon by the circle officer or the respondent number
3.
3. Full stop. The respondent number full stop. The not respondent number 3, respondent number 2. Respondent number 2 and 3.
Good.
The respondent number 2 shall accordingly refer the dispute between the petitioner and the respondent number 5 to the authority constituted under section 51 of the 2013 Act. Full stop. At this stage, comma, the notification number RLA 300/2013/PT-Roman 2/176 dated 27/5/2020 issued by the additional chief secretary to the government of Assam, comma, Revenue and DM Department provides as follows. Provides that, states, shows the authority that has been constituted to decide the dispute between the parties under section 76 of the 2013 Act.
Right.
The contents of the notification dated 27/5/2022 issued by the additional chief secretary to the government of Assam, comma, Revenue and DM Department is reproduced herein below. You reproduce this. Good stuff. Okay. Then the authority on receipt of the reference from the respondent number 2 with regard to the dispute between the parties shall decide the said issue at the earliest
6 months.
and preferably within a period of 6 months. Notice will have to go, this have to. Evidence have to,
1 year. Madam.
and preferably within a period of 1 year from the date of receipt of the reference.
My lord, the compensation for the land may be paid to the petitioner, my lord. That is.
We will have to see whether you are the owner or not.
Well, that is established. my lord.
They are not the owner. They have purchased the land. They have not got.
You see, if they have purchased the land and if there's a registered sale deed in their favor,
Registered sale
then
deed.
that is all that is required.
I have annexed those.
No,
And
no,
revenue
there is
board,
a-
my lord, the ADC, revenue board, everybody has given.
No, there is a dispute because the.
Let that be decided, that be decided also, because there are, you know it very well, but how can I decide now? I'll have to take a call as to
No, no,
whether you're the
no.
owner.
Because he's the owner, not the owner, my lord.
That he has admitted. He's
Then,
not-
my lord, I have to get it. The revenue board has decided it. Your lordship may see the
No, that
revenue
is
board
not the
doesn't.
subject
Page
matter of this
134.
petition matter.
Yes, this is the,
Page
so,
134.
This is not
you
the
see, with
subject matter of
regard
this.
to the compensation amount, you file a separate writ, we'll decide that. This is only with regard to Zeerath compensation.
Yes.
This is only with regard to Zeerath compensation. Let us
Yes.
see your prayer in the writ petition.
My lord, that we have challenged that, my lord. That is not there. We have challenged that on the
Then,
bankruptcy letter,
then,
my lord.
yeah, you have challenged only that, you have not
That-
prayed for compensation. You make a separate prayer.
Well.
Well, for that,
Well,
the writ petitions accordingly disposed of.
my lord.
My lord, I will be excused for one thing. Item 20, my lord, I am sitting from morning. Now we have come to know that it has been passed over without our consent. my lord. It is a tender matter. We are the highest bidder. There is no stay order also.
The government also was there.
Yes, we have no information to give.
That is the problem. You
I
see,
leave it to your lordship. my lord.
no, today also and yesterday also, I didn't allow adjournment without the other side being present.
Exactly, there is.
But today, the government was there. So I was thinking, maybe, and they said that they have taken the permission. Who has written the order 18 and 19? 19 and 20, sorry.
I have
Kuntal,
20.
you have for 20.
Yes.
20, I think someone was there.
From our side, there was none.
None.
From our side, there was.
What to do?
Anyway, your lordship has passed over. I have nothing. I have just informed you, my lord, because we are the highest bidder.
Oh, Miss MD Bora is ill.
Yes.
SC Transport.
Yes, yes.
She's ill. She could not come.
Maybe, but we have. not-
Adjourn for 1 week.
Date today. I may take the date, but
No date is given, I think. No, no date was given.
after 1 week it may not come. That is the problem.
Give a date. Item 20. Tell them. You tell them, but you see, Mr. They might have already uploaded. You'll have to change it. Yes, next.
My pleasure, Lordship. Well, I'm appealing for the petitioner in this case. Well, there are two petitions, 13 and 14. 13 was filed earlier and by the same party, and 14, oh no, yes, 14 subsequent. And in both these cases, my issue is termination of
Contract.
contract by the National Highway Authority.
And what are you challenging in the second case?
My lord, what has happened? By the first case, I have challenged the termination. By the second case, I have challenged their action in floating tender for engaging some other contractor. No, the second petition possibly there is no stay. They have engaged a separate contractor.
Now for the first issue,
So no, second one has become infractions.
second one,
That your lordship can dispose of.
okay, right, second one. Heard Mr. Mazumdar, learned senior counsel for the petitioner. Petitioner, no, petitioner.
Yes.
Assisted by Mr. Huh? S.K. Deary, S.K. Deary. D. Mazumdar, huh? Then, are you the second one?
Yes, madam. I'm appearing for respondent number one.
Okay, no, the learned senior counsel for the petitioner submits that the rate petition has become infructuous and can be closed. Full stop. Mr. P.J. Saikia, learned senior counsel, for the respondent number
1, 2, and 3.
1, 2, and 3.
1, 2, 3, 4.
1, 2, 3, 4. Assisted by Mr. R.K. Talukdar. Also submits that the rate petition has become infructuous. Full stop. In view of the submissions made by the counsels for the parties, the writ petition is closed as infructuous. Item 14. Now, item 13.
So far as the item 13 is concerned, my lord, here, since I am challenging the termination on the ground that opportunity of hearing was not given in terms of the provisions of the tender agreement itself.
Is there any arbitration clause?
Arbitration clause, my lord. What? Clause is there, but
Then-
here is a case of a direct contravention of the terms of contract. And anyway, my lord, notice was issued earlier, and on 18th of April 2022, status quo order was passed to be maintained in relation to the bank guarantee. For
Bank guarantee,
performance guarantee, performance security,
bank guarantee,
my lord.
bank guarantee. Can the court pass such an order?
What I'm saying is this court passed an order, but
It has, okay, we have passed an order.
my lord, dissolving that order, they have already invoked that bank guarantee. Of course, the money is lying with them.
So,
And Contemplation has been filed, contempt is pending. And there they have given assurance that we are not disposing of the amount or spending this amount, it's lying intact. So in that view, the matter, this writ petition is required to be heard,
no, but then you see, there are two parts to it.
my lord.
First of all, if there is a arbitration clause,
My lord.
then as per the various judgments, I think it has to go before an arbitrator. Number two, with regard to the BG,
My lord.
lot of water has thrown down the bridge. So what remains? And in fact, I doubt whether they cannot exercise their power for encashing a BG.
No, but encashment of BG is permissible, provided that the termination is valid. The clause itself says if you terminate, you are entitled to encash.
Okay, yes.
Now, when we challenge the termination itself, and if your lordship decides, notice was issued in this case, they have filed the reply, it's otherwise ready. What I'm saying is, my lord, if your lordship ultimately decides that termination was contrary to the provisions of the agreement itself, then the question of going to tribal arbitration may not arise. Your lordship has decided in many cases, this is not one, because there are judgments also of the Supreme Court that ABL constructions case is there, where the Supreme Court says, even if there is an alternative remedy, even there is an arbitration clause, in some matters we can decide. There are judgments.
If only those three conditions are fulfilled.
Yes, three conditions, yes. Three conditions. So what I'm saying.
So are those conditions met?
Yes, madam. And today, madam, so far as today, madam, this matter will take some time. Either your lordship issues rule and fixes a date for hearing, or if they want that admission state itself can be disposed of, or may fix any other day.
But Mr. Sakia.
In fact, on this similar identical item, my lord, they have withdrawn the petition, they have availed the my lord alternative remedy and taken. Similar. And here, of course, my lord, now they are admitting.
There are some
in this
cases-
petition. Now they are admitting that there was arbitration clause.
No.
The writ petition, there is no mention about it, and my lord,
No mention.
no.
No, it is there. But when the agreement is executed by both the parties, there is no question of a suppression.
In
You are
fact,
also aware, I am also
No,
aware.
Mr. It's not that. You see, when there is an arbitration clause, I think you know it much more than me. And you have been on this side all along. And I'm quite sure you have been harping upon that arbitration clause all the time.
My lord,
So-
agreement is there.
Ah,
Anyway,
then-
Lordship may
Then
hear,
you avail of the arbitration clause, so nothing remains.
Lordship may take it up on 29th, my lord, 29th.
And why? We can dispose it of here. It won't take you just show me the arbitration clause, which page it is.
They did not annex it also, my lord, very, my lord, skillfully, my lord, skip this portion. I have to give the extra portion, my lord.
I'll satisfy your lordship that this will fall in one of the three conditions which
Oh.
lordship is referring to.
Even if it falls,
My lord.
it doesn't mean that the writ court has to hear it. It just says that if it falls, then we still have a discretion whether to really take it for our consideration. It's a
Madam,
discretionary power.
My lord, your lordship will hear us in detail, but here is a case where the agreement itself says that before you issue the termination order,
Uh-huh.
you have to give us opportunity in 2-3 ways, man. One, to cure the defect, and the other to give an opportunity of hearing. All those things are there. They have to terminate it. It's a case where there is no other, man, arbitration, when we go to arbitration where certain disputed questions are there which have to be proved, where a necessity of recording evidence is there. Then your lordship says, when there are judgments, I'll produce those judgments. Then your lordship says that we are not going to hear all those things because we will not record any evidence here. And it's a case involved disputed questions of fact. It's not that case, man. I'll make my submission on the basis of the judgment.
No, first of all, that arbitration clause has not been provided. There's no mention, is it?
No mention, my lord.
If there's no
and,
mention, then-
you will find, my lord, from 66. That's the clause 23. They have
You show me
annexed-
where you have mentioned it.
Well. No, we have mentioned.
My lord, this
Let us see.
Article 23, my lord, at page 26 of the writ petition. And it goes up to, my lord, page 66. And there.
Article 23, where? Page 26.
Page,
This is the critical date sheet,
page 60,
60.
page 60. That is with regard to termination.
60.
60.
Termination, yes.
Termination. My lord, it's Article 23. And it goes up to, my lord, page 66. And thereafter, my lord, from 67 onwards, my lord, they have put the Article 28. The article, my lord, this dispute resolution is in Article 26. So.
Dispute resolution, that has to be first that has to be first invoked.
Evoked.
Then only you can go
Yes.
for the arbitration.
Yeah.
And that is also not here.
I think there is, sorry. Yes.
And in this case, 50% of the work was completed.
None of these clauses, my lord, they have invoked. And they have also not mentioned in the writ petition.
Then let them go. They'll go for the dispute resolution clause first. There is a clause to attempt a conciliation. If that fails, you go for arbitration. You cannot come straight away litigating your case by way of a writ petition.
Nothing. Let it come in the next week, madam. I'll satisfy your lordship.
No, no, just show me where have you mentioned
My lord.
that there is an arbitration clause? That's all. If it is not there, then I'm closing it.
What time? Yeah, nice. We have mentioned about absence of any efficacious and alternative remedy, but
So
specifically.
you have mentioned the absence of any alternative remedy. That's a false statement. That's an absolutely false statement.
No, we have said that there is no efficacious alternative because they.
There is an efficacy.
Madam, we-
So you have said there is no, which
No,
para?
my lord, we, Lordship will kindly see one thing, my lord. No, my lord, Lordship will kindly see one thing. We approached at a time when they were going to invoke the bank guarantee. We are primarily on the protection of the bank guarantee
Bank guarantee was invoked after termination or prior to termination?
after termination.
Yeah.
That's what I'm saying, my lord. After termination, immediately they were going to, well, once they invoke the bank guarantee, everything goes. What
no.
remains?
Whatever it is,
Because
you are
Lord-
aggrieved with the termination?
Lordship will kindly see. both
No,
the
no, let
bank-
us be very clear. Are you aggrieved with the termination?
Yes,
You are aggrieved with the termination. Then, but there is an alternative, there is a remedy for
Minor-
the termination.
my lord will kindly see one thing. If the termination is illegal, if your lordship goes by the clause itself, if the termination is illegal, they cannot invoke.
No.
They cannot invoke the bank
Maybe,
guarantee.
but that is a different issue now. That has gone. Now,
No,
those
and-
issues are,
And more so, madam, when the contemplation is pending, madam, right now, if your lordship takes up the matter for final disposal, madam, our position in the contemplation will be taken. Lordship will take it after the contemplation is disposal, madam, no difficulty.
no, when will the contemplation be closed, we do not.
No,
know.
it is fixed, madam, it is fixed.
No, you see, that order, that order will still remain. Only thing is that the dispute with regard to your termination,
Yeah.
that will go before the arbitrate. Only that.
My lord,
We'll make it clear in the order also.
My lord, I'll satisfy your lordship that in a case, there are not one, my lord, there are several cases where the Honorable Supreme Court has said, even if there is an arbitration clause.
No,
even if there-
that is there, but then you see, if you have been hiding facts from the court
My lord,
with
my lord,
regard to, with regard to whether
my lord,
there
let
is.
us- my lord, let us be very clear one thing. Here is a case where if the arbitration agreement, sorry, the agreement between the parties itself contains an arbitration clause. Where is the question of hiding? My lord? It is, my submission will be. on the-
That
My
you
lord,
should have
lordship
mentioned
kindly
it.
see, on the first day, they should have raised this objection that there is an arbitration clause.
No, they are not raised. The court has raised it now. The court has raised
I'm
it
not saying
today.
that the Honorable Court cannot raise. What I'm saying is, my lord, they cannot be said that they were not aware of the arbitration clause. I had suppressed. They are aware of it. I am also aware of it. There's no question of suppression. It is not a case of suppression, my lord. I cannot suppress a fact which they are already aware. I can suppress a fact which I am aware and I don't bring it to the notice of the Honorable Court. It's not a case of suppression.
No,
of material fact.
I am not on that actually. There's suppression or not anyway.
No, no.
Since there is the
No,
arbitration
if-
clause, you go
well,
there.
If your lordship is satisfied, there is no question of suppression. The next question remains is whether in the face of an arbitration clause, we should go to the arbitrator. Well, I'll satisfy your lordship that in spite of that arbitration clause being
No.
present in the agreement, here is a case where your lordship can decide the correctness of the termination agreement only on the basis of the averments made in the writ petition and the affidavit filed by them. Lordship may take it up on 29th minute, I'll satisfy your
In
lordship.
the other writ petition.
Yeah.
Order dated 25/5/2022.
Yes,
In the
Page-
other writ petition.
yes, I got it.
There, paragraph 4,
Page.
on the other hand, Sri so-and-so Learned Training Council, NHIDCL for the respondent number 1 to 3 submits that even the earlier writ petition may not be maintainable in view of availability of an arbitration clause and the present notice has been issued only in the interest. So when
They are
this has been
aware.
already indicated.
True, but they are aware.
It is not
Not a
that
case
Malad,
where I
for
have
the first time we are urging Malad that it's not maintainable.
Lots of kind
Okay.
of about 21, 9, well, I'll
No
satisfy
case,
the lordship that
no,
in
no, no, it's
spite
too
of the
far
arbitration
away.
clause, this repetition will be maintainable, my lord.
No, no. Maintainable,
Madam,
but you see, I'm not saying it is not maintainable.
My lord.
I'm saying that I'm not inclined to exercise my discretion
But true.
when there's an arbitration
My lord,
clause.
I'll satisfy your lordship that it
It's
is
a
a case,
discretionary power.
my lord,
226 is a discretionary power.
Absolutely.
I don't have to decide.
my lord.
It's my discretion whether I want to exercise or not.
My
Then
lord,
I'm exercising my
my
discretion.
lord, what I'm saying is, my
You
lord,
can go to the division bench and say, he doesn't want to exercise his discretion. You have all the right to say that.
No, what I'm saying, my lord, I'll satisfy your lordship that your lordship may not exercise the discretion in favor of sending the matter to arbitration. Because here is a case where I am challenging the termination order only on the ground that there is a violation of principle and natural rights. And the clause mentioned, there's no question of recording any evidence before the arbitrator. If I go, don't have to record any evidence. Only on one point your lordship will decide. Your lordship this is a case where in spite of being a arbitration clause, your lordship can decide. This is what I'm establishing, madam. And I want to rely on 1 or 2 judgments, thereafter your lordship will pass whatever order your lordship desires. This is my submission.
I don't know that exactly identical items, similar clauses, they themselves have filed an application saying
True,
that
my
the
lord.
arbitration clause is there and
My
they
lord.
have already invoked
My lord,
the
there are
arbitration.
all
And
cases are
therefore,
not same, my lord.
this matter
In
has
that case, we
may
have
be
said
allowed to be
yes.
withdrawn. my lord.
We have ourselves said yes, my lord.
Yes, so same clause, same contract. my lord. Only with regard to different side. my lord. Paragraph 6 onwards, my lord. It is their application, they wanted to withdraw on the for the availing the arbitration before the appropriate.
My lord,
forum.
my lord will
Paragraph
kindly
6
see one
onwards.
thing
Just a
here.
minute, just a minute.
Paragraph 6 onwards.
Yes, you give me your submission now. No, we won't list it for another day.
Then let it be taken up tomorrow. I'll bring those judgments tomorrow.
I've got other cases tomorrow, Mr. Council. What do you think? Every day I've got a lot of.
Today, my lord, I have not brought those judgments. 2 judgments I produced your lordship tomorrow, my lord.
Okay, one thing,
Early
his
morning.
basic case is
Right.
that no notice was issued
My lord.
prior to termination. Is that a fact?
Nothing
No.
else, my lord. Only that much.
Not at all. my lord.
Huh?
Not at all. my lord.
Not at all. Just show me
Yes.
one document that
Yes.
notice.
Yes, yes,
That is the only stand.
My lord.
yes. That was
Ground.
the only.
Just show me that.
My lord, let me kindly take up my affidavit in opposition.
Yes. Which page?
Page 46. And everything has been mentioned in the termination order itself, all detail. will be
Okay,
cases-
the termination order. Anyway, let me see page 46 for
Yes.
once. Yes,
Well, this is notice of intention to terminate the contract as per clause 23, 1.2.
notice for intention. Yes.
Lordship. Then page 72, my lord.
Just a minute. And why was the contract terminated?
Because of failure to perform, my lord, as per the, my lord, milestones.
As per the milestone set.
milestones, set. Well, this was way back in 2019, thereafter cure notice was given. He was given ample opportunity and ultimately, my lord, well, after various notices, my lord, this, my lord, termination order had to be issued.
My lord, I'll just show two documents, if your lordship permits me, just two
Yes,
documents.
yes.
Page 174 of the writ petition, they have given us a termination notice,
174.
170. 174.
This is
This is 4th of April 2022.
final notice of termination.
My lord.
So they've given you notice.
My lord, this they have withdrawn. Page 178. Page 170.
422.
My lord.
Page.
Page 178. Please refer this office letter number so dated 4/4/22 in respect of so project regarding final notice of termination. This letter is hereby withdrawn. Thereafter, no notice and state with termination. Man. Then next page, page 179, madam, is the order of termination.
Yes.
Well, in fact, this has been withdrawn because it was not.
And then, just sorry, ma'am. Then page 62 of my repetition says, clause 23.1.2 of the agreement, that you have to give me a notice. Has got my page 62.
Yes.
23.1.2, without prejudice to any other rights or remedies which the authority may have under this agreement. Upon occurrence of contractor default, the authority shall be entitled to terminate this agreement by issuing a termination notice to the contractor, provided that before issuing the termination notice, the authority shall by a notice inform the contractor of its intention to issue the termination notice. Nothing is there. This is our case. You issued a letter, but subsequently he withdrew. This short point can be decided by your lordship, my lord. This is what I'm saying. This is the only point your lordship is to decide, nothing else.
What about page 46 of the AI, the affidavit on position and 72?
Page 46 is a letter of 22/5/19, my lord.
19.
After they issued that 4/4 termination notice, all earlier letters have lost its significance. Otherwise, they will say, no, our letters do not carry any meaning. Whatever we want, and whenever we want to issue, we will issue. In fact, my lord, this page 46, even otherwise will go on the ground that after this, they have given us extension.
When?
Extension is permissible, and that extension was given. Seven 21, my lord. 7/7/21, they have given us extension.
7/7.
21.
Page.
I'm just giving the page. So after you exercise your power to extend the period for completion of contract, earlier notice even if given, page 157. my lord. Page 157.
Yes.
That was in fact not necessary because sufficient numbers of notices were given.
No, you see, what the council is saying is that you had first issued a notice on 22/5/19.
Gotcha.
Then a cure notice was issued on 9/10/20. Correct? 9/10/20, page 72 of the affidavit in opposition.
Gotcha.
So now assuming that this satisfies clause 23.1.2,
Yes,
assuming.
yes.
However, this is nullified by the extension given to you
Exactly.
on 7/7/21.
Yes.
Now, after 7/7/21, has any notice
Yes.
been issued by you? Now, according
Page
to
90.
him,
Page 92
page 92
Gotcha.
of the
of the affidavit notice.
~ 12/8/21, okay. Then after that,
After that, my lord,
We gave a reply to this man.
now you see, what about this notice that was given to you, that was given by you on 4/4/22,
Yes.
which you have withdrawn
gotcha.
on 6/4/22.
Because on 8th we have issued the termination order, my lord.
But you have withdrawn your notice.
Repeatedly, we have been giving him, my lord, the notices and his, my lord, there are other correspondence also by which, my lord, we have asked him to, my lord, improve the, my lord, the progress.
Okay, after this 92, page 92,
Gotcha.
12/8/21, which notice is there? Another notice?
My lord, he, pursuant to that, he submitted the reply, my lord, that is at page 98.
Yes, then
Gotcha. Then again, my lord, at page 8, your lordship will find my page 80. Sorry, my lord, this one, my lord. Page 77, my lord. That is again, my lord, just a minute.
'77,
These are, of course, my lord, 29/11/21,
77.
77.
This is not a notice.
My lord, asked him to improve the work, my lord.
That is a different thing. Asking to improve the work is not a notice.
Gotcha. Then, my lord, page 79, my lord,
Yes,
79, my lord.
this is again nothing. This is not a notice. It's just you're informing him of some things. It's just information. You're informing him. Is he a counsel? Huh?
Legal officer, my lord.
Huh?
Legal officer, my
Legal office.
But this is for notice for taking action under the contract agreement for extremely slow progress.
That's not a notice.
Then
Under,
again, then that is at page 79. But the requirement of the clauses, that intention is sufficient, but thereafter again, we have been giving the some time to improve.
notices have been given.
Yes, there was legal compliance that has been done with the notice of termination. Then again, on 12/1/2022, similar direction was issued.
When? Notice you mean, is it a notice? No.
No, notice, the first one was, that what the, as per the,
Okay.
clause, 23, the first notice was issued on,
Okay,
22/5/19,
anyway.
and thereafter 12.
So these are the notices, I mean,
Yes.
this is.
These are the-
Let me see the impugned order is at page 179.
179.
Correct. Heard Mr. D. Mazumdar, learned senior counsel for the petitioner. Assisted by Mr.
SK Deori.
S. K. Divedi.
Deori.
Dury. Also heard Mr. P. J. Saike, learned counsel for the senior counsel for the respondents number 1 to 4, assisted by Mr. R. K. Talukdar. The petitioner has put to challenge the impugned order of termination dated 8/4/22, by which the contract awarded to the petitioner has been terminated. Full stop. On the ground that, full stop. The challenge to the impugned order of termination is on the ground that no notice was issued to the petitioner prior to the termination. Order dated 8/4/2022, which is in violation of clause 23.1.2 of the contract agreement. Which reads as follows. Page 62, from here to here, okay? Next paragraph. The further grievance of the petitioner is that though this court had granted an interim order of status quo on 18/4/22 with regard to the bank guarantee submitted by the petitioner, bank guarantee number with the bank guarantee number 1908 1 GPE R003 720 dated 29/12/2020, issued by the UCO Bank. Submitted by the petitioner in pursuant to the allotment of the contract work of 4-laning of the National Highway number 37 Janji to demo section JHANJI to demo section DMO section from KM 491 full stop 050 to KM 535.250 in the district of Sivsagar, Assam under SARDP-NE on engineering, procurement and construction bracket EPC bracket close mode. Whatever I said, too long, I forgot.
The further grievance of the petitioner is that this court had granted an interim order on.
Full stop, then full stop. Continue. However, during the pendency of the writ petition, the respondents have encashed the bank guarantee, and for which contempt case number
242,
242 of 2023,
2022.
2022 has been filed. Full stop. Next para. The petitioner's counsel's prayer, the petitioner's prayer is for setting aside the impugned termination order, as the same has been issued in violation of the principles of natural justice. Full stop. Next para. The case of the respondent is that various notices have been issued to the petitioner prior to the impugned termination order dated 8/4/2022, and as such, there has been no violation of the principles of natural justice. Full stop. They also submit, no, the counsel for the respondent also submits that the respondent's further case is that the petitioner has not made any mention of the fact that there was an arbitration clause in the agreement made, in the contract agreement made between the parties. And as such, and as such, the respondents, the petitioners would have to avail of the alternative remedy available. Full stop. Next para. Next para. The records, the documents on record show that notice dated 22/5/19 and 9/10/20 had been issued to the petitioner as per clause 23.12, 23.1.2 of the contract agreement. Full stop. However, the respondents had subsequently given extension of time to the petitioner by letter dated 7/7/21. Full stop. Thereafter, notice notice dated 2/8/2021 had been issued to the petitioner under clause 23.1.2 of the contract agreement, to which the petitioner made a reply. Full stop. Thereafter, a final notice of termination was issued to the notice of termination dated 4/4/2020 was issued to the petitioner. Which was subsequently withdrawn.
But this notice of intention has not been withdrawn. By the letter dated 6/4,
Just a minute.
another letter of 4/4 has been withdrawn.
Acha.
As termination, notice of termination remains.
Huh? No, 4/4/22 is the final order of termination.
No, madam, that was not under Article 23, madam. It was the last one is of 12/8/2021, that is at page 92.
So this,
This remains.
this,
Then we have the option to terminate it, madam. But then, madam,
so this, according to you, this 4/4/22 is not under 23.1.2.
no, madam. This, your lordship, can you see, by that, my lord,
And what my learned friend is saying, if I have understood, my lord, by 6/4/22,
Yes,
page 178,
yeah.
this 4/4/22, that is the intention to terminate, was not withdrawn.
no, that was not a, my lord, that the 4/4 is a page, your lordship.
174.
My lord, my
174. This is not under, my lord, 23, my lord.
Yes, this is not under 23.
It's not under, it is a general. my lord,
Correct.
just
I have not said it is under 23. Have I said? I have not said this under 23.
lordship has,
I said 4/4, that 4/4/22, whatever I said. Data.
final notice of termination.
Thereafter, a final notice of termination dated
That is
4/4/21
correct,
was
my
issued to the petitioner, which was
That is-
subsequently withdrawn.
that is not a, my lord, notice of intention.
Correct. I have not said it is it's a final notice for termination.
Yes,
Termination of what?
agreement.
Termination of the, my lord, contract, my lord, no doubt, my lord, but then the.
It is not under 23,
It is not
1.2.
under as,
Yeah.
as required, my lord.
Ah.
That was issued, my lord, on.
On
12/8/2021.
12/8/21.
So that remains.
Ah, that
Thereafter, my lord,
remains.
sequence of events have.
Correct, that
taken
remains.
place.
That remains, but I'm just putting it down.
Lordship. Thereafter, my lord, sequence of events have taken place. So, my lord, we did not issue, we thought, my lord, good sense will prevail on him, he'll improve. But in the meantime, PILs have also come up before this court. And because of the, my lord, road condition, etc.
Anyway, I'm just putting this, I'm going to give him time just to give those two judgments, that's all.
Right.
I'll make a short date, just for, so that on the next date, we just have to, it won't take too much time.
Right.
Okay, what have I said?
Thereafter, a final notice of termination dated 4/4/21 was issued to the petitioner, which was subsequently
Withdrawn by letter dated 6/4/22. It may be noticed here that the final notice for termination, inverted commas, dated 4/4/22 has not been made under clause 23.1.2 of the contract agreement. List the matter on when?
29.
Too far off. 23,
23, my lord, other matters are fixed.
okay.
Friday, we just- 29th is a Monday or something.
Monday is difficult, motion matters.
Then next day, 30th.
We can do it on 25th, hearing date.
25th, I've got two matters already.
26th,
Strong matters. 26th Friday also can take up Friday.
26, 26. Okay, 26. I don't
If
know.
it is on 35, but 29 or 30, it is possible.
29 or 30.
30th one is a Tuesday, it will be better.
Okay, 30. This is the matter on 30. D, first up. It is also noticed that there is no mention of before that, They say it is also noticed, no. The writ petition does not contain any averment to the effect that there is a dispute resolution clause or an arbitration clause in the contract agreement. And neither has the said clause been made a part of the annexures.
No, it's there.
Huh?
Part.
It is not there.
It is.
No, it is not here.
Huh? Oh, isn't it?
It is not there.
Oh,
Article 26 is not there. Article 23 to 28 is there. 23 and 28 is there.
Yes. Always.
17, my lord, I pay for the PDCL. Morning hours, my colleague tried to mention, madam, will seek some time. My lord, because we have filed an affidavit on the threshold, my lord, it is raising the issue of mental pay. Now, my lord, since it is admitted, we need to file in detail affidavit, my lord. We have craved leave on the council.
In fact, I am led by Mr. DK Mishra. He is in the midst of NI cases, my lord, in court number 1. So let it be posted on 25th, my lord.
Let him file affidavit. When can you
We
file
will
a
need some
detailed
time, my
affidavit?
lord.
How much time?
Detailed affidavit, at least 4 weeks, my lord. We need some time.
Okay,
My lord,
Mr.
in that case, let it be posted in August because I will be out of station during June, July, my lord.
But let it come.
Mr. D. Gogoi
Well.
is granted 4 weeks time
Well.
to file affidavit, detailed, no, is granted time to file affidavit in opposition on the merits of the case.
Merits of it.
List the matter on
August time in August.
date.
In the
You
meantime.
don't want a date.
Any second.
He will not file within 4 weeks.
Let it be 10th of August. 10th of August.
10th of August.
This is the matter on 10th of August as prayed for by the council for the parties.
Always.
Please, my lord, during the pendency of the proceeding, the parties have amicably settled the dispute, my lord.
Huh?
The parties have amicably settled the dispute.
Hmm.
So the petitioner wants to withdraw this.
Okay, right. Heard Mr.
DM now.
DM Nath, learned counsel for the petitioner who submits that the parties have settled the dispute and he would accordingly like to withdraw the writ petition. Mr.
A Dhanuka.
A.
Dhanuka.
Dhanwad appears for the
All the responses.
all the respondents. On the prayer of the petitioner's counsel, the writ petition stands dismissed as withdrawn.
But draft has been handed over to my learned friend.
Huh?
A draft has been handed over to my learned friend.
What draft?
The dispute is settled, that's why I have received that. Let me record. That can be recorded.
Okay, it is, Mr. Dhanwad, then all the respondents submits the draft number what?
633694.
633694 dated
10/5.
10/5/2023
Hmm.
for an amount of
54,64,500.
has been handed over to the petitioner's counsel
Yes.
today.
Okay.
That's all. The writ petitions accordingly closed as withdrawn. Don't say dismissed, closed as withdrawn.
My lord, in this case, I'm appearing for the respondent number 7, my lord. And we need some time to file affidavit.
My lord, the services have been completed, taken both to the registered the justice service and affidavit has also.
Are you running the market? No,
No, they have not given me the chance. They're running it from their own side.
they're running it.
Yes.
No, they can run it.
I'm still waiting. I'm being the valid period. I'm still waiting.
Ah,
for my turn.
How much time?
For 2 weeks time.
Mr.
Yes,
Not may I submit, on last date, your lordship directed me to produce a record.
Ah.
And I think the record is quite quite evident, lordship. Lordship may take up the records document and dispose of the matter also.
He wants to, the problem is now he wants to file affidavit. Now, if he wants to file private response, supposing I pass an order against him
Initially, we extended a period
Huh?
of 1 month. Initially, we extended period.
for 1 month,
for
yes.
1 month. Okay.
Yes.
Now he is not running. We are
He's not running this. So what have you got? You've got no role to play now.
No, my lord, only thing is that, my lord,
I am the second highest bidder.
Huh?
I am the second highest bidder.
Then you make a challenge. Where's your writ petition?
It was rejected.
You file a writ petition.
Well,
But my only issue is lordship, authority has decided to go for retender lordship.
I know. So we'll have to decide whether that should be allowed or not.
That is my lordship. One, whatever they have done, lordship, it is as per the provisions of their own directions or regulations. Lordship. It is there in the record.
So what do you want now? You want me to show, you want to show the records? Show me the record, then we'll decide the matter.
My lord, they have in their own terms and conditions, like in number 41 of their terms and conditions of the notice. They have stated that the commissioner has the right, if he finds that the highest bidder, if it is not, he is not eligible also,
No.
then the second highest bidder will be taken into consideration. And now both the first highest bidder and the second
Where is
highest,
their terms and conditions?
that is page number 18. 1841. Pardon, my lord, it's page number 19.
Page number
41.
9.
41. The rate quoted by the bidders should not be excessively high. In case it is found to be excessively high, unreasonably high, then the commissioner GMC reserves the right to reject, cancel the bid amount quoted by the tenderer while without assigning any reason. In that event, the second highest bid would be considered as a valid offer, if otherwise not found unfit or improper. So that they have
What was the estimated amount for a bid? Estimated amount of the bid?
the main from our side we had given that is in.
No, estimated amount made, estimated value given by the government.
1 crore 3 lakhs 41,540.
And you had quoted?
1 crore 25 lakhs. Sorry. That is 2 crore 1 crore 25 lakhs 15,000.
And lordship, he was the respondent number 4 was the existing legacy lordship. And
Respondent number?
The private respondent lordship.
Respondent number 7.
And he
7.
quoted 1 crore 51 lakh. Lordship. It's a realistic price lordship because he was the existing lessee.
Then why was he there?
He was rejected
Only because of 30 rupees, my lord.
Then that was the thought.
He was disqualified, my lord. Because
Our concern is both sides lordship.
Why?
My lord, we have to, my lord, deposit 10% of the earnest money, but only 30 rupees is less than.
Oh, you deposited less?
Yes, 30 rupees only, my lord. Even I have already deposited on that day.
How much did you deposit?
My lord, I have deposited.
You make a small affidavit.
Yes, my lord.
You make a small affidavit, I think better. Otherwise, you both of you will make the affidavit. Right. Mr. Mr. K. Singha, learned counsel for the respondent number 7, and Mr. P. Nayak, learned counsel for the GMC. Are given 2 weeks time to file affidavit in a position. List the matter. Give a date.
my lord, in the meantime, interim may be continued at least. And I'm also ready, my lord, to even go to the second highest.
Interim order to continue till the next day.
I can go to his rate also. I'm ready.
On 30th.
Why was the second highest not?
Same, like
Same
the request height,
There were three
documents
bidders
were
were
not.
there, lordship. 3 bidders were there. 2 have been rejected.
Why?
Same reason.
2 weeks.
30 rupees.
30 rupees, 35 rupees.
Can you mention that in your affidavit? I don't know, but I don't know why Mr. Singha has not filed a writ petition then.
My lord,
Yeah.
because there is a specific clause in the tender that the right to reject and accept the tender is already vested to the parties, my lord, commissioner.
So what? But it has to be reasonable.
That's why, my lord.
You're giving, you cannot, you're accepting the blanket power given to them.
No, my lord, there is some instances also there, my
Okay.
lord.
My lord,
Some citations are there.
Yes, my lord. So all the power.
Anyway, let them file an affidavit because then it is interim order passed, they shall continue till the next day. Yeah. Next.
Date 31. Obliged. 31. Obliged.
Item? 32. Yes.
Lordship, this is the appointment of arbitrator, Lordship.
Even number?
Yes,
My lord, we have received the, after his application for appointment of arbitrator, my lord, I have received the communication.
give him a copy of. So we can appoint an arbitrator.
My lord, well, I have given the list, my lord, for the recent notification.
Where are you based?
But I am basing at Chandigarh now.
In Chandigarh,
Chandigarh, but I have done the work in Tezpur.
Tezpur.
Tezpur is also my house.
So all your evidence, all your witnesses will be from Tezpur.
Tezpur only.
So it will be better to have a judge from,
I'm in another one case, Indian Council of Arbitration was appointed by court number 2.
Ah.
The same I request to appoint because that she is the bar counsel over there, a senior counsel, and having familiar with the policies of the Dutch department. This is better so that she can able to give a quick. And I'm having the judgment of court number 2 also, under which she was appointed, being a Indian Council of Arbitration member, Lordship. I can submit.
This is an application in the section 11. And the notification issued, my lord, giving the list of arbitrators is pursuant to the directions by the Honorable Chief Justice. My lord, the appointment has to be from this list.
there is a list.
There is a list.
Lordship, that will
Not from.
they are familiar because already they're familiar. This arbitrator, she is conducted so many cases in this court.
Mr. Counsel.
The counsel, Lordship.
No, Mr. Petitioner, please keep in mind that this is a notification issued by the Guwahati High Court. And now this court is bound by this notification. So the arbitrators here, you choose one of them, you choose which one.
I have gone through like I'm having the notice that doesn't suits me because I have already having 2 arbitrators, but from the earlier list, there is not getting going goodly actually. Prolonging.
Taking too much time.
Lordship, the same thing was told by the court number 2. I requested and the court has agreed to me and appointed this arbitrator.
So-
Kindly, this is the judgment of court number 2 and this is the arbitration council. Lordship, because of this is case of
From any
35.
of the honorable judges, retired judges, my lord. Three
Huh?
lists. Honorable judges of the Guwahati High Court, my lord, serial number 3, 4 and 5. From there, my lord.
Lordship, one submission, this is 35 years old cases, Lordship. Very old case.
No, Mr. Counsel, you see, one thing is that, no. This is of 22 order.
Lordship,
This notification by the High Court is of 23.
but.
But what do you mean, but?
Lordship, certain changes were there.
Mr. Counsel, this is by the Chief Justice.
Lordship, but again, I have to run again therefore, because as I'm facing with the arbitrator. It's like,
I'm trying to give you a chance. That is, I'm going to appoint whoever I want. I don't have to go by your. I'm just giving you a chance to select one. If you're not selecting, I'll select.
give me some, Lordship, give me next time, actually, I have to, because I'm already.
So when
from
do
the
you want? When do you want? Which date?
Then 7th of June, I'm coming back then, sir, 7th of June. Because Lordship,
Your matter pertains to 1993. Is it
89, Lordship,
89?
89.
89. So 23 years ago, you had this problem.
Lot-
Oh, no, 33 years ago, you had this
33,
problem.
Lordship.
And now you want June. When the list is here in front of you, you see, we'll list it tomorrow. You go and look at it, you talk to your friend in Tezpur, that arbitrator, whoever, and you say, who is the best? There are retired session judges, there are high court judges of the Guwahati High Court, or you want Supreme Court judges, you decide.
Lordship, should I submit one thing? That there is a Supreme Court decision of 2022. I'm having the name of the party. The Supreme Court says the bar council can be appointed the arbitrator. If
Mr. Counsel,
Lordship,
Mr. Petitioner,
Lordship,
I am bound by the notification issued by the Guwahati High Court. If you don't want to do this, what I'll do is, if you want to adjourn, I'll adjourn it for a year. You can come next year, you give me a date, and you don't hurry.
kindly for
I'll
7.
give you tomorrow or you give next week. We cannot keep it pending, just like this.
Lordship, my case is at Delhi on 17th. Actually, I have to, that's why I'm requesting for 7th June. Lordship.
7 June, okay,
Lordship,
all
7th
right,
June.
right. Heard the petitioner in best person. Also heard Mr. H. Gupta, learned CGC, who submits that the respondents do not have any issue with the appointment of an arbitrator by this court. From the list of arbitrators reflected in the notification number 47 dated 26/4/2023 issued by the Registrar General, Guwahati High Court. On the prayer of the petitioner, list the matter on 7 June.
Obliged, Lordship.
May I plead the lordship?
Yes,
Lordship, this is a this matter relates to the tender matter.
yes.
There were all 16 bidders and all of them quoted the same amount for the work.
Now, for the work, what is the work?
It's a construction of Brahmaputra dike from Ajalangi.
So everyone gave the same bid amount.
Yes,
Then
then.
you are not selected.
Yes, Lordship, but the responding authorities without means without the it issued work to the respondent number 3 and without any justification by adopting pick and choose policy.
Without giving any reasons why the respondent number 3 was selected.
Select.
Why was respondent number 3 selected? That's
Lordship,
one.
in fact, she has not annexed any work order, Lordship. I have procured it from the department. It was issued in the month of May 2022.
Yeah.
And today morning, they have informed me that 65% work has already been.
No, you see, that's why, he just wants to know why he has been selected. This is the reason, that's all. What else can be done?
Lordship will issue notice.
You just take time, go call and then we'll. He just wants, yes, what else?
No, it's from Majuli though.
Majuli. So you see, actually there's no case. All of you have given the same amount, the same bid amount. Number 6, is it? Number 3 has been selected.
16 bidders were there.
Now, what is wrong with selection of number 3? What, according to you, is the failing of respondent number 3? Why shouldn't respondent number 3 be given?
Lordship, the petitioner is also technically qualified.
So what is, no, you see, I understand. So according to you, respondent number 3 is also qualified.
Yes, sir.
You are qualified, respondent number 3 is qualified. So all of you are equal. Now, what is wrong with the state respondent choosing the respondent number 3 over you. What is wrong? What right of yours has been violated? Just show me that. Because you said that respondent number 3 is also technically sound. Same amount of money given also by. So what is why should you have been selected over the respondent number 3?
Looks like all are technically qualified, but
Correct. All are technically qualified, but your case should be, your right has been violated
yes,
by
Lord-
selecting the respondent number 3. How has it been violated? You see, you have, when you come to a writ court, you have got to show the court that your right has been violated. You can say, look, I'm the lowest tenderer, or the respondent number 3 is not technically qualified, but you have just said that he's also technically qualified. Everyone is technically qualified.
but without the, I mean, what I have to say is, during the time, kindly come to para number 7. Lord
Yes,
Chief.
yes. Para number 7, yes.
That the petitioner begs to state that the respondent authorities thereafter prepared the comparative statement of all the 16 bidders for the state work under RIDF 27th of November for the year 21 to 22. At Majuli LEC assignment published in the website. From the comparative statement published by the department in the website is clear that all the 16 bidders quoted same amount of so and so only for the said work. Now, Lordship, come to para number 9. It is clearly stated there that the petitioner begs to state that though the tenders were opened and the comparative statement were prepared in the month of February 22 itself, but due to the by-election of Majuli LEC, no work order was issued to anyone. However, it is now come to know that the respondent authorities have recently issued work order of the aforesaid work of the respondent number 3, who has offered same bid amount like the petitioners and the other bidders. So, Lordship, the respondent authority arbitrarily and illegally issued the work order.
How? Why? Why should you be chosen over that person? Why should you be chosen?
That's why I have come.
No. Madam, you have got to show this court that you should have been chosen over that respondent number 3. Why?
Because during the by-election time, there was no work order were issued. So
No, ma'am.
the
Madam,
work
it's like
has been
this.
stopped.
Supposing you take part in a exam. Okay. And there is a job. And the authority says that whoever gets the highest mark will be selected. So that is very simple. Whoever gets the highest mark will be selected. Supposing 2 persons get the highest marks, 2 of them same, and 1 is selected. Now, when you make a challenge to that person's selection, you'll have to say as to why you should have been selected over the other. If you say both of us got the highest mark, but he was selected, that is no argument. No doubt, the government should have clarified as to why you were.
At page 20, Lordship.
Page
That
20.
notification is not with me, Lordship. In the tender notice, Lordship, last line, Lordship, note 3.
Ah.
The award of contract will be as per norms fixed by government notification number so and so dated 12 July 2018 with respect to quoting rates for work. Lordship, notifications is there. Lordship, in such situation, what generally chief engineer do, Lordship, he uses his discretion. Lordship.
Correct, I know, but you could have just brought an instruction that since they were all equal, we have selected, since they were all technically,
In fact,
same thing that, he has said.
But the respondent authorities arbitrarily issues the respondent.
Madam, when you file a case, you cannot ask them to justify your case. You have got to first make out some point that some wrong has been committed to you. There is no wrong committed to you. Anyway, right. Heard.
Also, we have taken the first steps.
Huh?
We have taken the first steps on 24th of.
No, there's no case, madam. This is, if we're just going to keep it there pending, it will not, nothing will happen. You have got to show something that you were discriminated, you were unfairly treated. Nothing is there. Heard, Miss so. What is your name?
A by.
A. Payan, learned counsel for the petitioner, who submits that the petitioner, along with 15 others, took part and participated in the tender process pursuant to the NIT dated 21/12/2022 for construction of Brahmaputra dike (balance path) from Adia Lengi Pokhumara L0 L equals to 1500 m close under RIDF dash Roman 27 capital of NABARD Roman 27 of NABARD for the year 2021-2022 at Majuli LAC, SM. The petitioner's counsel submits that all the 16 bidders quoted the same bid amount of rupees 1,99,30,500 and all were declared to be technically qualified. However, the respondent authorities issued the work order to the respondent number 3 by adopting a pick and choose policy. The petitioner's counsel submits that the work order issued in favor of the respondent number 3 should be set aside. And the respondent should be directed to adopt a fair procedure for selection and issue of the fresh issue a fresh work order. Mr. P. Nair, learned counsel for the PWD,
Yes, sir.
submits that what is the document you had?
Lordship, this is the notice to proceed with the work.
Submits that the respondent number 3 has completed 65% of the work,
More than 60.
has completed more than 65% of the contract work. After the respondent number 3 had been issued a notice to proceed with the contract work by letter dated 31/5/22. He however submits that he has not received instructions as on date with regard to why the respondent number 3 has been selected over the others. He however submits that there is no illegality in the selection of the respondent number 3, as all the tenderers had quoted the same bid amount and were all technically qualified. I have heard the learned counsel for the parties.
But may also record the delay in filing the writ petition.
Huh?
Delay in filing the writ petition. Also. The work order was issued in the month of May to 2022 law.
Oh.
So it's a 2020, sorry, Lord.
He also submits that there is a delay in filing the writ petition in as much as the work order was issued on 31/5/2022, while the writ petition was filed on 27/9/2022. I have heard the learned counsel for the parties. It is settled law that a person approaching a writ court under Article 226 of the Constitution would have to show that some legal or fundamental, no, some legally enforceable right of the person has been violated. So in the present case, there is nothing to show that any legal or fundamental right of the petitioner has been violated. In as much as all the 16 tenderers had quoted the same bid amount and had all and as they were and that they were all technically qualified to do the contract work. In that view of the matter, full stop. Further, as more than 65% of the contract work has been apparently concluded, this court does not find any ground to exercise its discretion in this case. The writ petition is accordingly dismissed. Madam, next time you should find out what is, you've got to make some submission to the effect that you have got a better right than that person. What you're saying now is that we are all equal. Why should they select him over me? That's what you're saying. Why should they select him over me? But that should not be that is not the way that will get you a favorable order. You will have to show that you have a better case than the respondent number 3. And that some right of yours has been violated. Next.
May I please, your lordship? Lordship on 31/3/23, lordship. In view of the writ appeal 188/2022, lordship,
Huh?
I have withdrawn the writ petition, lordship.
Yes.
And during withdrawal, lordship, while making the prayer, actually inadvertently, substantial delay was caused in filing the appeal before the appropriate authority, lordship.
So let the appropriate authority take a decision.
Lordship.
You file an application for condonation of delay before the authority, giving reasons. And let it be decided by them.
Lordship, the law is very specific in that matter, lordship. 60 days and
Cannot be condoned.
another 30 days, they can condone, lordship. Beyond that period.
But then when you came to this court, was
is-
it within the
No, lordship.
limitation
No,
period?
lordship,
Then
because there was some communication that he has made with the authority, because this was passed without any jurisdiction, lordship. On that ground, we came before your lordship. But in view of
but you
the
came under 226.
226, lordship. Because my grievance has not been addressed by
right.
the authority, lordship.
Yes, anything, madam? We allow. Heard Miss M. Bhattacharjee, learned counsel for the applicant, and Miss
Ardeka,
Ardeka,
respond number 227.
respondent number 227. Gustav. Next para. The applicant's counsel submits that the order dated 31/3/23 passed in WPC number 1843/2023 should be modified inasmuch as, while the applicant had been given the liberty to approach the appropriate forum by way of filing an appeal in terms of section 35 of the Finance Act 1994.
85.
Huh?
85.
There's section 85 of the Finance Act 1994, this court had inadvertently forgotten to allow the petitioner to file the appeal by condoning the delay that had already occurred for filing the said appeal. Full stop. She accordingly prays that the delay in filing the appeal may be condoned by this court. The full stop. Next, Miss R. Deka, learned counsel for the respondents, all the respondents.
No, one number 2 to 7.
For response number 2 to 7, submits that she has got no objection to the prayer made by the applicant's counsel. Full stop. On perusing the order dated 31/3/23 passed by this court in WPC 1843/2023. This court finds that the writ petition had been closed with liberty being given to the applicant to file a statutory remedy to file appeal before the competent authority. First up, however, this court had not taken into consideration the fact that the appeal would have been barred at the time of disposal of WPC number. The appeal would have been barred in terms of the Finance Act 1994 at the time of disposal of WPC 1843/2023. In view of the above fact, and keeping in view the principles of equity, this court is of the view that the petitioner, that the applicant should be allowed to avail the statutory remedy available in filing the appeal before the competent authority. Which should be disposed of by the said authority on the merits of the case. On the merits of the appeal. The delay in filing the appeal should accordingly be condoned. The applicant is the application is accordingly disposed of.
Highly obliged, Your Lordship.
I, on behalf of Mr. SKKL,
Okay, on behalf of Mr. SKKL, learned standing counsel for the response number 2 to so.
Obliged. Obliged.
This case, my lord, we have challenged the selection process adopted by
You have challenged what?
selection process.
Selection process. For what?
It's a selection process for the board of directors and everything.
Board of Directors.
Board of directors and everything. Yeah, my lord, what happened, my lord, in the nutshell.
So you are, so
I'm the
others
chair.
were selected.
I'm the shareholder.
I am the shareholder,
I'm the shareholder.
but you are not selected. You are not,
No, my lord,
not
we
elected.
are not concerned. I did not participate for the selection. My concern is that, my lord, during the ban period, my lord, pandemic ban was there, my lord. They have selected their own persons, my lord, against which item number 27, lordship will see how the corruption has been done by the bank authorities, my lord, the board of directors. Anyway, my lord, the first case is that, my lord, in violation of law, my lord,
So how many Board of Directors are there?
my lord, around, my lord, 15, 20, my lord, there, that is the minority is there, my lord.
How many?
Yes, I'll just check it up.
15?
His whole contention is that the annual general meeting was without quorum.
Okay, the AGM was without quorum.
That is a moot question.
So that means how many? Nine?
No, my lord, here is what the
At the AGM.
AGM was adjourned and in adjourned meeting as per the rules, no quorum is required.
For adjournment, no quorum is required.
There is a rule.
No, my lord, that has been dealt with by.
Just a
our
minute, just a
coordinate
minute.
batch.
So his case is that there was an AGM. And,
And in the AGM, there was no quorum.
and they
And
will.
the second ground is that the AGM was held during the COVID period. The COVID protocol was not followed. These are the only 2 points.
That is a different issue.
Yes, madam. This is
So,
the-
so the number one point is that the AGM was held without a quorum.
And during the COVID period.
That is the second point.
That is the second point.
So if it is held during the COVID, if there is no bar, what is the problem?
Yes, and this is a statutory AGM, my lord. The statute prescribes that whenever the term of 5 years is complete, AGM has to be held for electing the next BOD, Board of Directors. That's it.
Just a minute.
And I can place the rules, my lord, if you want.
My lord, before starting by my learned friend, my lord, I'm the petitioner, I'll bring some technical attention of the
Court
thing.
query.
Is that, my lord, this coordinate branch of this our High Court, my lord, a series of cases has been discussed, whether it is mandatory or not, my lord.
To mandatory or not for what?
As per the law, my lord, 10% quorum is the mandatory. If
10
you should
10%.
permit me, I can supply the copy, my lord. Lordship can mark
10% of what?
10% of total
Members, shareholders.
It will-
10% of shareholders
Yes,
have to be there to have a AGM.
AGM, my lord. Without this cannot.
So
be.
how many was there?
Only 110, my lord, 101.
So 101 would be how much percent?
No, my lord, total is 4,000.
Oh.
4,000 something.
So they don't make up 10%.
10%, they cannot make it.
So for total is 4,101 came for the AGM.
My lord, only 101. Total is.
No, I don't think he's disputing facts. So 4,101
My
came.
lord.
So there was no quorum.
4,265 total,
There was no quorum.
no quorum.
No quorum, so there was no resolution, nothing.
There
could be.
cannot be.
There cannot be. So that is what you are,
That is the case.
then
Then, my lord, the approval was given, my lord.
this AGM was held when?
Yes.
Azimus was held on, my lord, 18th September 20.
And when the repetition was filed.
AGM held on
18th September 20,
18 September 20.
my lord.
And when the repetition was.
Then, my lord, I made a complaint.
Just a minute.
Lordship can have a look at page 31.
Page 31.
31. The minutes of the AGM, my lord. Total strength of the member, my lord, 4265, 4,265. Lordship got it. Number of members present, 101.
4265
Is the
members present.
no, my lord. Members present, 101.
Yes, 101.
Yes. And that got selected, my lord. And that got the approval, my lord. Lordship will see relevant page at page 34.
Page 34.
34. Approval was given, my lord.
Page 34, approval given.
On the
Okay.
extreme right hand side, my lord.
Approval given on?
Given on, my lord,
My lord, the handwritten portion.
Huh?
The handwritten portion on page 34, my lord.
No, I don't have the date.
date not.
Anyway.
From the forwarding letter, it reveals, my lord. It has been sent at page 38, my lord, 21/9/20,
I do not know.
page 38. Affidavit.
Anyway, so it was approved.
My
Then?
lord. Then, my lord, government has filed an affidavit, my lord, the concerned authority. They filed an affidavit holding saying that, my lord, they have annexed a document at page 45. I think
Yes,
Lordship has got it annexed, my lord. One.
yes.
Sri Midul Kumar Saikya, Inspector, hereby appointed as observer to attend the AGM corporate so and so, scheduled to be held on 9/11 at so and so time in auditorium hall of so and so, that the Harisabad Goswami
Road, Panbazar, he is directed to look into the guidelines of the regarding so during pandemic to be followed by the bank authority AGM to submit the observation report to the AGM general meeting. A total 20 number shareholders were allowed to attend the meeting physically and others may attend the meeting through online mode. The management should make necessary arrangement to online transmission of the meeting for all the shareholders. But from the record, my lord, it is not been followed. On the last occasion, my lord, when the honorable court the perused the records in original, my lord, the very person Midul Sekia was not been signed in the minutes. Though he seems to be observer. Deviation of this order, my lord, how come, my lord, the authority can approve?
You said AGM was held on 18/9.
My lord,
Initially, it was notified for 11, my lord, then adjourn AGM was held on 18.
Okay.
adjourn meeting. My lord. But here, my lord, lordship will see direction was issued, my lord, to issue, my lord, online mode from the record. It does not reveal the online mode, nor, my lord, it will be seen from the record. One person is saying that it has been done at Uzan Bazar. Somebody says that it is done in Pan Bazar. There is a contradiction in the record, my lord. So for names of the director is also there, my lord. It is there in the English, so lordship can have a look. Now the question comes, my lord. They said, my lord, they have taken plea by virtue of the bylaw. Whether by bylaw says adjournment meeting quorum is not required. This honorable court, my lord, that very matter, a series of case has been decided, my lord, recently. Lordship can have a look, copy this one. Copy this. Lordship will see WPC 3041 of 21.
Yes.
Operative part, lordship directly can skip, my lord.
Order.
Yes, sir. Paragraph
3041/2021.
My lord. I'll supply. my lord.
Date of order, my lord.
Date of order of 15/11/2022.
Maybe it is reported in GLP most probably.
I don't.
Anyway, my lord, lordship will see paragraph 20 of inner page, my lord. Now coming to the section 34, it would be seen that subsection starts with if any time of the meeting there is no quorum, meaning thereby the meeting has commenced with the quorum being present initially during the continuance of the said meeting quorum falls. Then in such a case, the presiding authority shall adjourn it to a such time as they may think fit forthwith, announce the same. It is further stipulated that the business set down by the meeting brought forward at the subsequent meeting, whether at the meeting there is a quorum or not. At this stage, this court finds that relevant to draw the comparison, the words used in the legislature section 33(4) and 32(2) and 34(3). The Cooperative Society said, in the meantime, subsequent meeting can only be found the subsection whichever do not find the section 33(4), 32(4) of this. In difference between treatment of the meeting adjourned under section 33(3) vis-a-vis 33(4), 34(2) can also be seen in a reading section of so wherein though there is also interference made to them subsequent meeting under section 34 stipulates that no business other than the business so. Then lordship kindly turn to directly lordship can turn to
Just a minute, just let me read this.
para 22 BC. In the backdrop of which is that's better the section 34.
Just a minute. Yes, next. Which para?
Para 22.
Just a minute, let me see 21. What does it say?
Lord.
Yes, what is your case?
My case is that, my lord, they are not quorum. As from the, let's reveal.
From the very beginning.
Very beginning, lordship has
So
seen
that will come under section,
section, my lord.
under the bylaw or what section?
No, my lord,
Section
in the
33.
Cooperative Societies Act, lordship, can I have a look? Please?
Yes.
It has been decided, my lord. Human, 34.
Yes, yes. Dilakil, yeah.
Page 32, my lord, of that book. Section 34, subsection 3.
34.
Read with bylaw 22.
Same thing was raised question.
So 34-3, so it shall be adjourned to the next date.
Next date, but the quorum has to be 10%.
In the next date, no, quorum is not
Yes, quorum
required.
has to be there.
As per this judgment is not required.
Yes, it is required, my lord. Para
Where?
22, my lord.
Huh?
Para 22, my lord. I was relying upon. Coordinate bench has said, my lord, paragraph 20.
What coordinate bench?
22.
Yes.
In the backdrop of the, it would be transferred that section 34(1) of the Cooperative Society Act would show that there has to be minimum quorum of 10% of the member eligible to vote. The said quorum, minimum quorum can be enhanced by bylaws in question, but it cannot fall below 10%.
Then?
It cannot be below 10%.
Then,
my lord, 34 of the Cooperative applies to the situation where the meeting could not be commenced on the account of being no quorum. Accordingly, adjourned statutory same day, next day, week. At the same time and place. However, the chairman of the committee of the decision to adjourn the matter later, not later than 15 days, as may be specified in the bylaws. It is interestingly to note that section 34(2) of the Cooperative Societies Act stipulates that the chairman of the meeting can adjourn the meeting to the later date subsequently mandated to the 7 days, but the Cooperative Society Act is silent. How the chairman of a meeting opine that in addition, in section 43 of the Cooperative Society Act, the president and chairman have been inadvertently categorized. Then lordship would see the ratio of the this judgment, my lord, para 25. Below that, my lord, 6-7 line, my lord. It is clarified that lordship has come across.
which page?
Page 23, my lord,
Yes.
thus above the 25.
Yes.
para 25 with the middle 6-7 lines, my lord,
Yes.
of that paragraph 24. It is clarified that legislature had clearly demarcated the status of an adjourned meeting, subsequent meeting. In the impugn meeting, there has to be compliance with section 34(1). Cooperative society, whereas the subsequent meeting, there is no necessity, subsequent meeting, no need necessity, but first meeting, it is mandatory.
Now, so
Quorum has to be section 31 of the seat provided, so and so. Section 33 and 34(5) of the cooperative says it complied with. The quorum is the analysis to be at that the meeting, adjourned meeting on section 43 of the, is the adjourned matter. There is a requirement of having quorum of 10% of the members eligible to vote or any other
so
quorum
please
as
read solely from therefore.
my lord.
Just read from therefore. Para 25. Therefore,
Therefore,
from the above analysis,
analysis, it is clear that an adjourned meeting.
in an adjourned meeting,
Meeting adjourned under section 33 and
34.
34 of the cooperative, so there is a requirement of
having a quorum.
quorum of 10% eligible to vote meeting or any other quorum as mandated by bylaws of the cooperative, which even is higher. The order dated so and so are in consonance of the cooperative society. Admittedly, the adjourned meeting, there is no quorum. Therefore, the said petition number so and so divided committee accordingly dismissed. In that case, my lord, what happened?
No, I think you're jumping.
No, my lord. Lordship, para 26.
No, you come to page para 24.
Yes, my lord. In the backdrop of the scheme and besides under section 34(3) of the Cooperative Societies Act, it would be seen that the word and the business set down for the meeting shall be brought forward to the subsequent meeting. Whether at such meeting quorum is not or has to be interpreted to mean that the subsequent meeting upon the complaints of the first part of section 34(3) and section 35(5) cooperative, so that there is no requirement of quorum. The legislator intend to clear
There is no requirement of the,
quorum for subsequent.
so
Yes, I'm coming, my lord. The legislature intent is clear to the give additional opportunity shareholders of the society to present the subsequent meeting. However, shareholders cooperative society fail remain to present. The legislature intensity is clear. Subsequent meeting can be proceeded in respect of their being.
it's clear, the subsequent meeting can proceed irrespective of there being a quorum.
My lord, the law laid down by this honorable court is that, my lord, whatever I understood from the first day of the meeting, my lord, first day of the meeting, 10% has to be there.
Correct.
Subsequent meeting, my lord,
Doesn't have to be there.
it is not required.
So you see what happens is, in the first meeting, 10% has to be there.
Right.
During the meeting, supposing they become less, straight away it is adjourned, correct? It is adjourned to a subsequent date. And on the subsequent date, whether or not there is a quorum or not,
It is not mandated.
quorum is not mandatory.
First, my lord, my contention is that.
In the first, they are required to be there.
Required to be there.
They are required to be there, but in the meantime, during the meeting, if they become less than the quorum, then the entire business of the day will be shifted to another date.
Another bit, but quorum has to be there, my lord. For shifting of that, my lord,
Initially, quorum has to be there.
has to be there, must. From the record, lordship will see from the first meeting.
But then there are cases, supposing there is no quorum at all.
So meeting cannot be, my lord, cannot be viable. Cannot be viable because, my lord.
So what is your case in this case?
My case is that, my lord, no government has, there is no quorum, my lord. During the pandemic time, my lord, lordship kindly have a look. My complaint to the authority, my lord.
Okay, so you are saying,
My lord,
since there was no quorum on 18/9,
my lord, on the since from the first day.
when was the second meeting held?
Notice it is revealed, my lord, 11 September.
First meeting was on 11 September.
First meeting was
11
Fixed
September.
on 11/9.
fixed on 11, but it did not happen on 11/9.
11 happened, my lord.
Huh?
Adjourned.
It was, acha,
Lordship will see page
11/9, it was adjourned. Okay, where is that?
My lord,
that
page
you-
28 we seen, my lord.
Page 28. Yes.
Annual general meeting 11/9/20, the bank of the financial year 19 so and so venue so and so, Guwahati so and so, number of shareholders 4,265 on so and so, number of shareholders of the quorum,
10% was there.
10% of the holder, and number of shareholders is only 22,
Acha, 22, yes.
only 20.
Then, so, okay, so now, then in the AGM held on 18/9, what happened? The resolution passed, they were accepted and approved.
In the
So you are aggrieved by that.
yes, I'm agreed by
Yeah,
the
you are aggrieved by that,
AGM.
stating that in terms of the judgment of this court, the second
No, initial to
since in the initial meeting there was 10% was not there, then in the subsequent meeting, the resolutions passed could not be acted upon,
my lord,
as the judgment
my lord,
requires that in the first meeting 10% has.
10% has to be there. Then question of my lord, 10% above it can be. But
No,
it
that is
cannot
a
be less than 10% at the initial.
Yes, that's all.
And apart from this, my lord,
And what were the resolutions passed in the second meeting? The board of directors were.
board of directors have been selected.
Yes.
Now, my lord, apart from this, my lord, the affidavit filed by the cooperative department, my lord, just now, which I have read out to your lordship, is that, my lord, annexure 1, my lord. Yes, my lord. They said, my lord,
The next year, one of the writ petition, what?
no, my lord. Affidavit of 1, 5, 6, 7, and 8, received on 28/12/21. Page 39 onwards, operative part is page 45. The relying portion is the page 45, which I am relying at this point.
Yes.
Page 45. Mridul Kumar Saikia, inspector, he is appointed to secure the observer so and so, the urban so and so, held on so and so. This is saying about 9, my lord. 9 so and so additional Sanaram Saviti Goswami so and so. It is hereby directed to look the guidelines regarding the pandemic period following so and so to submit the observation report of the NGO. The 20 shareholders are allowed to attend the meeting, and physically, and others are to be by online mode. So from the record, we'll see, my lord, there is no online mode, nothing. Apart from this, my lord, the Mridul Saikia is not signatory, is not there in the any one of the minutes of the meeting, my lord, though he was the observer. And in violation
So
of
what?
in violation of this, they cannot.
Is it required that only a shareholder can be an observer?
No, my lord, I'm not saying about holder. But observer has to be fair person. Fair person has to be present in the place of voting place.
That
Record will
is,
see.
a fair person has to be everywhere.
My lord, I'm not going to that, my lord. But
An unfair person should not be anywhere.
my lordship is up to your lordship. Here, my
Tell me
lord,
one place where an unfair person should be.
my lord, I'm saying that, my
Don't-
lord, the middle Saikia, my
Don't
lord,
go into those.
my lord, I'm not
That's
talking.
a foregone conclusion.
My lord, the Midul Kumar Saikia, my lord, being an observer appointed, he nowhere put signature in the election process. Whether he is there or he is not there, it will reveal from the record. Record says something, my lord. Record says the meeting was held in Ujan Bazar. And where is Harishaba? It is there in Pan Bazar. Where is the accommodation? Lordship is aware, my lord.
Where does it say? You are
From the
saying
record,
things.
lord, record will
Where
see.
is the pleadings? Where is the prayer? My lord?
From the record will see, my lord.
No, where is your pleadings to that effect?
What is
Yes,
the
my
prayer,
lord.
my lord? Lordship?
Pleading, my lord, after perusal of the, we have pleading in the affidavit.
No, what
reply,
is your prayer in the writ petition?
Writ petition, I have said, my lord, what, and affidavit reply, I have taken, came to know all these things, my lord. Basically, my lord, for the meeting, my lord, I lost a complaint to the deputy commissioner pandemic
How
superintendent.
much more time will you take?
All lordship fixed tomorrow at 2 o'clock.
What do you think? Tomorrow we've got already matters.
Lordship's convenient, man.
You tell me, yes, let me hear him one thing. Yes, what is your case? I will not dispose of now. I just want to hear.
And I categorically deny and refuse the petitioner's case, my lord. We have also filed our affidavit. I'm representing the respondent bank.
His case is that in the first meeting
Yes.
held,
There was no.
there was no quorum.
Yes.
If there is no quorum, in the second meeting, is a quorum required?
Not required. My humble submission.
No, does the judgment say that?
No, but in my humble understanding, if you lordship permit, if there was quorum in the first meeting, occasion would not arise for adjournment, my lord.
No. You see, there are situations where quorum is there in the beginning of the meeting.
Correct.
Halfway during the meeting, they become less. Then what happens? So in that case, it has to be adjourned,
Yes,
and on the next day, you don't require a quorum.
true. But lordship will kindly.
Now, what happens when there is no quorum in the first meeting itself?
Yes.
If there is now
That situation is advised in 34(2)
34-2.
of the Assam Cooperative Society Act 2007, page 32. 34(2).
Yes,
If within 1 hour from the time fixed for the meeting of the General Assembly, a quorum is not present, the meeting shall stand adjourned ordinarily to the same day in the next week at the same time and place. But the chairman of the meeting, however, decide to adjourn the meeting to a later date, not later than 15 days, or as may be specified in the bylaws. So from the very beginning, if the quorum is not from within 1 hour, it automatically stands adjourned, my lord.
now, in the subsequent meeting,
Then 34(3) comes in, my lord.
huh?
Then 34(3) comes in, my lord. If at any time, my lord, any time. Also, you can mark these words. If at any time in a meeting there is no quorum, the presiding authority shall adjourn it to such a time or date as it thinks fit. And
Have you read this judgment?
No, man.
You please read it.
I'll
Then we'll,
Then we'll-
because this might not be as you think it is.
It will
I don't know,
be.
as a cursory look at it appears to say that there has to be a 10% quorum for the first meeting, and during the meeting they become less, and then it is adjourned. And in that case, in the second meeting, there's no requirement of a quorum.
True. That is
So
only
what
one
it's
situation.
what it's now, so what it means to say is that requirement of having that requirement of making resolutions without quorum can only be done when there was a 10%, the quorum was there in the first meeting, but in halfway they had gone off.
Yeah.
Became less. So it doesn't talk of a situation where there was no quorum earlier and no quorum in the second one.
Exactly. So, my lord, that is only one situation envisaged by this honorable court in the judgment, but the act takes care of it, my lord. Others.
We'll have to see. Okay, right, we'll adjourn the matter.
Yes.
There's no time.
My lord.
On the prayer of the parties, leaves the matter. After 2 weeks.
Date may be fixed, my lord,
After-
whole matter, my lord, and what happened when the other two cases, lordship will see, very ridiculous, my lord, board of director grabbing money in the name of daughter.
I don't know.
That is a record, my lord, record will reveal. So my prayer is that, my lord, a date may be fixed, my lord,
29.
my lord, any Tuesday, Thursday, my lord.
You're not there.
ঠিক আছে Tuesday, Thursday আছে Wednesday তো reach not হবে any day Tuesday, Thursday.
I've seen what you appear
Should
to
be
not
happy,
be
my
having a good case, huh?
My lord, can it be on 30th, my lord, instead of
When?
29th, 15th May? Because 29 is Monday, my lord, 30th
Okay.
is Tuesday,
The 30th.
lordship,
Deeply.
obviously.
You read the judgment.
I'll give you.
I think it might be against you.
Yes, there, my lord, same question was
We'll address the
raised,
lordship on this.
my lord, several courts, my lord. Then all the cases got clubbed together.
30 is not a motion day. 30 is a Tuesday.
30 is the Tuesday. May, Madhu.
May.
May, 30 तारीख, Tuesday.
What is this? Wait, life membership of the council, Indian Council of Arbitration.
Or earlier case,
Earlier.
my lord.
Another one.
Other
You
one.
did the arbitration, please.
Lord.